This is Boyle County. Can y'all see and hear me?
Yes, I can.
Okay, I'm getting him up here now.
Thank you.
You're welcome.
12, 13, 14 on the dot. When I started. It just we have so many range.
Oh.
Judges, jury ran across from his house.
Yeah.
I don't know. I'm getting paperwork. We're just sitting. Hey, David, I'm Ronnie Anderson, but we need to sit in for negotiation day, or you want to just? We'll just go ahead and see some paper. We're sitting down. She's on the move watching this thing.
All right, third report.
Please bow your head for a moment of silence, please. Thank you very much. Everybody be seated. Get some grand jurors.
Yes, sir.
Y'all come around. Thank y'all for coming in on short notice. We raise your right hand. Solemnly swear or affirm that you conduct your duties as members of the Cumberland County Grand Jury. Faithfully execute the duties with the protections and the Constitution of the United States. The Commonwealth, whatever happens the rest of the world. Are all evidence matters completely confidential that you hear and then you support the law as presented to you. Do that swear or affirm in case some of you don't take note. Okay, thank you very much. You can go with the clerk to the grand jury. Okay. Get those docket. Oh, there it is right here. Okay, we'll do the in-person docket out of custody. Commonwealth versus Ronnie Anderson.
Morning, Ron.
Morning. Are you Ronnie Anderson?
Yes, sir.
Born in 1960.
Yes,
Last four digits of your social security number 8591.
yes.
We have today a pretrial conference. What does the Commonwealth have to announce?
Your Honor, I believe we've reached an agreement this morning. If you want to set it for negotiation days, the next motion that will end up.
Next.
And that includes the drug course.
Yeah, he'll make a drug court assessment between now and then.
Yes.
Yeah.
Can we get the paperwork done today?
Yeah, we can.
Let's just do it today.
That's fine.
Can you just take a seat back
Wait,
there?
okay. Let's see.
Bronny Bays. Good morning. Commonwealth versus Bronny Bays. 22 CR 0026. Mr. Bays, you're here for pre-trial conference. Were you born in 1984?
Yes, sir.
Last four digits, social security number 5442. We have a trial date set for this, don't we?
Now, Your Honor, there was a trial date. It was continuing with Mr. Bates, trying to counter offer. I've been told, and I don't know, Nathan, but I assume that that's happening.
Why did we continue it the last time?
We didn't have all the bank records and there was a little bit of investigation.
Do you have the bank records now?
I was gonna be able to get it.
Let's set a trial date then. You have witnesses you need to subpoena.
I think they're pretty much all local within the state.
Okay. It's good, I'm sorry. How about July 25th?
I will not be in the state, Your Honor. The last 2 weeks of July.
Okay, let's move it up. What are the last 2 weeks of July? You consider the 30th and 31st?
Actually, I will be back the 30th and the 31st, Your Honor. I forgot that's a Monday and a Tuesday. I'll be back on the
30th is Sunday and Monday.
Okay, sorry. Yes, I'll be back the 31st.
Let's set this on August the 1st. I'm not really inclined to accept a plea at this juncture, so let's just,
Your Honor, we did make a counteroffer. It has.
I don't, we've already set this for trial. and We've had an opportunity to settle this. I'm gonna let a jury determine this case. This is not, let's make a deal, you know.
Now, I talked to Jason, she does not. She does not. It's not bad to go with.
Okay, if you have any other motions that are pre-trial, you do it the next Thursday, okay?
Thank you, Your Honor.
Be here and prepared for trial August 1st. James Becker.
That's 8. Yep.
Cumberland versus James Becker. Here for the purpose of arraignment. Are you represented by an attorney? Yes, Ron.
Represented him in district court, Your Honor.
He's not eligible for,
It was, okay, it was a couple of years ago, I think.
he's not eligible. I'll let you do for the purpose of arraignment.
Okay.
You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging with possession of controlled substance in the first degree, possession of drug paraphernalia, and possession of marijuana. Mr. Bailiff. And that over there, you understand those charges, you acknowledge the identity of your client. Receive that away formal Regan arraignment. You're pleading not guilty, reserving all pre-trial motions.
Yes, Your Honor.
You are relieved in this case.
All
Sir, you be back here. What's your negotiation date?
July the 12th.
Be back here July 12th. at 1 o'clock and be back here July 5th for your next court date, the 12th and the 5th. Will you write those down,
Yes.
Brent? You need to get an attorney as quickly as you can. You have a significant income and you can afford an attorney.
That's wrong.
Okay. Oh, I'm sorry. I gave you, I looked at the wrong list here. July 27th. And your negotiation day was what again?
July the 12th.
12 and the 27th.
Okay.
I was looking at the district court list. It's posted up here.
This is for circuit court. I don't know if you need to coordinate.
She's on for some.
Here you go. Cumberland versus Kalen Bolton. Are you Kalen Bolton?
Yes, sir.
You were born in 1989.
Yes.
Last four digits of social security number 7555.
Yes.
We're here on 21 CR 00129. You're represented by the Office of Public Advocacy. What do you have here?
Your Honor, we have a pretrial diversion agreement.
What are the charges, Mr. Stockton?
Blake Constable.
Okay. Motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Is it freely and voluntarily given?
Yes.
Okay. Are you the same person named in indictment number 21 CR 00129?
Yes, sir.
Have you discussed this matter with your attorney?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
Do you have any impairment today? Are you
No.
impaired in any way? You know what's going on?
Yeah, kind of. I'm not really good with the board system. I mean, I understand that it's the,
You're
Pretrial
entering a
diversion,
plea
no.
today. Do you understand that?
yes,
Okay. Have you had plenty of time to discuss this matter with your attorney?
yes,
You feel like are you satisfied with her advice?
yes,
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at the jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand that by entering a plea of guilty, you give up all those rights. You understand that?
yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In this case, they're going to recommend a pretrial diversion. In the event that I do not accept your plea and decide to impose a harsher sentence on you after you enter a plea, you have a right to withdraw your plea. Have you been previously diverted in the last 5 years? Have you had a pretrial diversion in the
No.
last 5
No, sir.
years? You got to say something. The machine doesn't pick up shaking up.
Okay, I'm sorry. Oh, okay, I'm sorry.
Have you had any felonies in the past 10 years?
No, sir.
Are
Never.
you currently on probation?
No,
You understand that you must fully complete the diversion programs, and if you do, the charges will be dismissed. However, if you come back in front of me violating it, I can revoke the pretrial diversion and schedule a sentencing, and then you would be a convicted felon. You understand that?
yes, sir.
Mr. Stockton, will you come around and present what the Commonwealth's case is? Miss Gordon Anderson will do it. Miss Gordon Anderson.
Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall make monthly payments at a rate of $325 per month, with the balance due and payable in 58 months from the entry of this plea. Said payments are to be paid to the Cumberland County Division of Child Support Enforcement. First payment is to be paid on or before August 1st, 2023, and on the first day of each month thereafter. The defendant owes a total of $18,222.07 $1.07 as of June 1st, 2023. This matter shall be reviewed by the court every 12 months. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained.
Is that what your understanding of the agreement was?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment as amended?
Yes, sir.
You're doing so of your own free will,
Yes, sir.
knowing your constitutional rights, have explained it's still your desire to give up those rights, to enter this plea and allow the court to fix your punishment within the range permitted by law.
Yes, sir.
Is that your signature on the motion offering pretrial diversion agreement?
Yes, sir.
I'll accept the agreement. We'll present it. Put your signature on there. Was that your signature? Did you look at
Yes,
it?
yes, sir.
You just give it to the clerk here. You'll need to meet with a probation parole officer over there.
Thank you, Your Honor.
Court cost is $210. Will you need some time to pay that? Yes, you will. I'll let you do it. It's $30 and I'm gonna give you a better deal on that. I'm gonna let you pay it $30 a month. Okay, starting 30 days from today. And the reason I'm doing that is because the child support should be the #1 priority in your life this juncture, because I will send you to the penitentiary if you don't pay it. You understand?
Yes, sir.
Okay.
I'll pay it, I promise.
Okay. Peyton Boer. Peyton Boer.
She called before and wanted that she could see.
Your Honor, I did speak to her yesterday. She is having significant problems with her pregnancy. And was going to the doctor as she left court yesterday.
You need to call her and tell her to come in here today, or have a statement that says that she's not able to be here, signed by a physician. If not, I'll issue a bench warrant for her at the end of the docket. Jeremy Curtis. Active warrant, Mr. Stockton.
Yeah, well, who do you see?
Okay. Johnny Daniels. I see I have the Marion County Detention Center on there. We're on Central Time here. If you, I'm gonna go ahead and take that case up though. When you turn the mic on, it probably was not clear. Commonwealth versus Edward Whitledge, 20 CR 0085. Are you Edward Whitledge?
No, sir.
You are?
No, sir.
What is your name?
Barney Shepperson.
Okay. Barney Shepherdson, I see.
Yes, sir.
20 CR 0030. Were you born in 1988?
Yes, sir. August 11th.
Okay. You're on a probation revocation. What do you have to say, Mr.
No,
Clark?
we've already had the hearing on this, and his parole's been revoked. That was the only reason you continued the case, so there's no need to, other than to revoke his probation, there's nothing to do in this case.
You want his probation revoked too?
I prefer it wasn't, Your Honor, but I understand the Commonwealth's position, and we did have the hearing last month and the violations were shown.
Okay, well, we'll revoke the probation, let him serve it all. That way he'll be able to serve according to the sentence. Marion County, thank you for participating. Y'all are excused. And now I also see, I guess, Boyle County on there,
Yes, sir.
James Hurst,
Yes, sir.
Commonwealth versus James Hurst,
Yes, sir.
the 22 CR 0013 and 22 CR 0038. Mr. Hurst, were you born in 1970?
Yes, sir.
Last 4 digits, social security number 2119.
Yes.
Mr. Stockton, what do you have to say in this?
This is a motion to revoke. Mr. Hurst had a 5-year sentence.
You're gonna have to speak into the microphone so he can hear you. Thank you.
Well, I just need to get situated here. Since we're doing these now. Yeah, he had a 5-year sentence. He was supposed to pay $3,500 restitution, which he has not paid. He absconded February of this year, and he also had a misdemeanor criminal mischief from the city of Bergen where he was allegedly stealing water. So those are the 3
I
violations.
read they supposedly cut a lock on the water line. What do you have to say for your client?
Your Honor, I would ask for some additional time to speak with Mr. Hirsch where he was in Boyle County. I've not been to get there in person and speak to him. I apologize to the court for that. I do know I have received word from his family that they have a portion of the restitution to be paid towards it, but
How much is the total amount?
$3,500.
They need to pay it all.
Okay.
Okay, I'll,
Someone here to pay 2,000. She said she had 2,000.
somebody's here to pay 2,000
Yes.
today. Well, we'll accept that payment today. And let me see here. We're gonna be back here on July the 27th. If who's here to make the $2,000 payment? You want to come forward here? Do you have it? What kind of form of payment do you have, ma'am? Cash. We'll go downstairs and pay it, and we'll take our hold off of him. He can be here on the 27th. Is that correct?
Yeah, he needs to report to probation officer, which he's not done in several months.
Yeah. Now, you understand that you need, Mr. Hirsch, you need to go to your probation and parole officer. Somebody's making a $2,000 payment here for you. And, you know, you need to go to your probation and parole officer immediately upon your release. You understand that?
Yes, sir. Will I be released from y'all today?
Well, as soon as the $2,000 is paid, I'm going to reschedule you for the 27th, but I want you to meet your what probation parole office?
That's,
Miss Mudd, are you the probation parole officer?
Your Honor, I was the officer that filed the violation report. Mr. Hurt and yes, I am the one that is out of Boyle County. However, I'm not covering that caseload anymore. I don't know where Mr. Hurst plans on residing at.
Where are you going to reside, Mr.?
I'm gonna resign. I own my own house, sir, but I would.
Where?
Bergen, Kentucky.
Okay, well, you know where the probation parole office is there in that town is?
Yes, sir.
If you get out today, I want you to go there immediately and report.
Yes, sir.
Will you inform them that he's supposed to be there by close of business today? And if he's not there by close of business, they inform me how issue a warrant for him.
Yes, Your Honor.
Okay, you have any other comment that you have to make about that? I know he's absconded and that's not pleasant.
Well, I mean, Your Honor, I assumed we would have a hearing today. You know, I'll defer to the court, what you all want to do at this time.
What else has he done besides steal the water and not make the payment?
Well, the absconding, Your Honor.
Yeah. How many days have you been in jail, sir?
So 30 plus, I think.
Okay, well, let me tell you something. The next
Yes, sir.
time I see you, you're going to take a trip to the big house. You understand what I'm saying?
Yes, sir.
Over there at probation and parole, and you do not make their life difficult. They have a difficult enough job without somebody gomming around and not showing up. You understand what I'm saying?
Yes.
Okay, thank you very much. Thank you, officer, for appearing today.
Thank you,
Am I
Your Honor.
done?
Judge,
Yes,
can I get somebody to send us a court slip so we can drop the holder?
we absolutely will do that as soon as possible. Okay,
Okay, thank you. Y'all have a
Thank you.
blessed day.
thank you. Okay, let's get back where we were here. Were we on Johnny Daniels? Those two
Yes, sir.
people showed up on fast times, the reason I took them out.
That's okay. I just had to get for you.
I'm well versed with Johnny Daniels. Are you Johnny Daniels?
Yes, sir.
Okay, were you born in 1985?
Yes, sir.
Last 4 digits, social security number 6056.
Yes, sir.
We're here on 23 CR 0014 for pretrial conference. You represent the Office of Public Advocacy. Mr. Stockton, what do you have to say? Okay. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
You need to speak up, move out of the way and let him have the microphone.
Nothing.
Okay. Are you the same person named in indictment number 23 CR 0014?
Yes, sir.
Okay, you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Are you impaired today in any way? Is there anything wrong with you?
No.
Okay. Have you reviewed the evidence? Feel like you're fully informed?
Yes.
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor. You have a right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes.
Okay, now I may consider Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to reporting any accepting your recommendation, I will order a pre-sentence investigation report be done for probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that? Just step to the left. Ms. Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. The defendant agrees to be assessed by the social services clinician and will follow any recommendations thereof. The defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky.
Sir, is that your understanding of Commonwealth's recommendation? Is that your understanding of it? Okay, are you pleading guilty because you are guilty?
Yes.
Okay, knowing your constitutional rights have explained to him, is it still your desire to give up those rights, enter a plea, and allow the court to fix your punishment in the range permitted by law? Now, this was time to serve or probated?
Probation.
Okay. You understand that after entering a plea, any future convictions can be enhanced as far as felonies, as far as the range of penalty that you have. You understand that?
Yeah.
Is that your signature on the document?
Yeah.
I'll accept the plea, order a pre-sentence investigation report. You'll be back here on July 27th for your sentencing. You need to meet with the probation parole officer over there. I'll continue on the same bond. Brett Davis. Commonwealth versus Brett Davis, 23 CR 0028. Are you Brett Davis?
Yes, sir.
You're represented by Mr. Cross, I see. Were you born in 1994?
Yes, sir.
Last 4 digits, social security number 2736.
Yes, sir.
The grand jury of Cumberland County has returned an indictment charging you with theft by unlawful taking more than 10,000, but less than 1 million in Class C felony. You understand those charges?
Yes, sir.
Acknowledge the identity of client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
You want a negotiation day?
Yes, Your Honor.
Okay. The negotiation date, you come back here for negotiations on July 12th, your next court appearance on July 27th. Now, I have a bond violation report here that says that you have not contacted pretrial services as stated.
Sir, we did last week.
You did?
Yeah, sorry.
Are you-
I was out last week.
Are you satisfied with what he's doing with you now?
Yes, sir.
Okay.
Thank you, Your Honor.
Joshua Duval. Joshua Duval.
Your Honor, Mr. Duval and there was a question about his paperwork and he's in the room and I was trying to answer that last question for him. If we could recall him.
Is he gonna do a plea? Is it what you're doing?
Yes, Your Honor.
Okay, Donna Firkin. Excuse me. Commonwealth versus Donna Firkin. 23 CR 0015. Are you Donna Firkin?
Yes,
You born in 1973?
yes.
Last four digits, social security number 6727. You're here for pretrial conference. What's the Commonwealth have to say?
Well, I was waiting to see when Miss Perkins would be finished with the rehab, so we can do a plea or go ahead and get one done. That's what we.
Yeah, you sent us the paperwork.
We got it, okay.
Yeah,
She said, okay.
She's still in treatment and doing very well. They're here with her today, so.
You got a plea agreement?
Yes, Your Honor. We reviewed the DUI. We just forgot to sign it.
Is this a misdemeanor, felony, or pretrial diversion?
It's a felony plea.
Motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily committed?
Yes.
Given rather. Is your judgment impaired today in any way?
No.
Are you the same person listed in indictment number 23 CR 0015?
Yes.
Have you discussed this matter with your attorney?
Yes.
Are you satisfied with her advice?
Yes.
Have you viewed the evidence the Commonwealth has against you?
Yes.
You feel like you're fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
I do.
You have the right to testify against yourself. No one can make you say anything. Right to speed trial, but jury right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor in a process issue. Compel attendance. The right to appeal this matter to a higher court if you lose, and right to require the Commonwealth prove beyond a reasonable doubt you're guilty of all the charges you understand. By entering a guilty plea today, give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowable law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait a pre-sentence investigation report from probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have the right to withdraw your plea of guilty and go to trial. Do you understand that?
Yes.
Go step to your left here, Ms. Gordon Anderson. Ma'am, will you listen very closely to what the prosecutor says? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500 plus court costs. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense, the defendant shall pay a fine of $200. The defendant shall pay a fine at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that your understanding of the agreement?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes. Yes.
Okay. Are you doing so of your own free will?
Yes.
Knowing your constitutional rights to explain to us, it's still your desire to enter a plea and allow the court to fix your punishment within the range permitted by law.
Yes.
You understand that by entering a guilty plea today, any future felony convictions could be enhanced as far as the range of penalties, and as far as your DUI, if you get another DUI, it can be enhanced. You understand that?
Yes, I do.
Is that your signature on the document?
Yes, it is.
I'll accept the plea and order pre-sentence investigation report. You will be back here for sentencing on July the 27th. Now, what are the court costs for the DUI? What? $1,400 is what your court cost. Now, you're presently in rehab, so what I'm going to allow you to do is, how much longer are you supposed to be there?
Probably to October or something like that.
Okay, well, are you working while you're there?
am.
Okay, can you afford to pay $30 a month?
Yeah.
Okay, well, what I'm going to do is charge you $30 a month, starting 30 days from today, and when you get out, it'll go up to $50 a month.
Okay.
Okay?
Okay.
Okay, you need to meet with the probation parole officer right over there.
Okay. Thank you.
Yeah,
Your Honor, would the court consider allowing her to appear for her sentencing via Zoom from the treatment facility?
I don't have any problem with that.
Thank you very much.
They've been kind about bringing her up here, and if she continues to be there, but I'm going to tell you, if you leave the treatment facility between now and then, you need to report to the Adair County Jail. You understand what I'm saying?
Yes, I do
Okay,
understand.
I hope you're doing well as a treatment facility, but I'm not gonna be gamed with it, okay?
Okay,
Meet
thank
with
you.
Probation parole officer. Sarah Handy. Good morning. Commonwealth versus Sarah Handy. 0044. Are you Sarah Handy?
Yes, sir.
Born in 1995.
Yes, sir.
Last four digits, social security number 3672.
Yes, sir.
You're here for the purpose of arraignment. You have the right to remain silent. You have counsel. The grand jury of Cumberland County has returned an indictment charging you with possession possession of a controlled substance in the first degree, possession of drug paraphernalia, possession of marijuana, and failure to maintain insurance. Mr. Bailiff, thank you. Counselor, you acknowledge that then your client received the indictment, waive formal reading and rendering and plead not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, we'll have, you need to be here on, I'm going to sign a reciprocal discovery order to get the information to your attorney from the Commonwealth to help prepare for your defense. You need to be back here on the 12th of July for a negotiation date and for the 27th of July for your next court appearance. Both of them are conditions of your bond, okay? Okay, thank you.
Thank you, Judge.
Dallas Hayes. Dallas Hayes. Okay, issue a bench warrant. Bench warrant, no bond on the bench warrant. Kenneth McIntyre. Commonwealth versus Kenneth McIntyre, 23 CR 0046. Is he just, the warrant just now been served on him? Okay, you need to take him and process him, and then I'll arraign him after he gets processed. Thanks, sir. Thomas McVeigh. Commonwealth versus Thomas McVeigh. 21 CR 0031. Are you Thomas McVeigh?
Yes, sir.
You born in 1983.
Yes, sir.
Last four digits, your social security number is 7685.
Yes, sir.
You're here on 21 CR 0031. For pretrial conference, Mr. Doctor.
Yes, Mr. Burbanks fulfilled his requirements in this case as far as cooperation in another case. It's Mr. Wilbur.
Okay.
Also, he stayed.
Mr. McVeigh, do you have any objection to this case being dismissed?
No, sir.
That's the correct answer. Okay. The bond be released from your bond, okay? John Metz. Commonwealth versus John Metz, 22 CR 00109. Are you John Metz?
Yes, sir.
Born in 1994.
Yes, sir.
Last four digits, social security number 8287. You're here today for the purpose of sentencing. Okay, we have a violation affidavit that has been sent about. It says 24-hour curfew, only leave for work, church, doctor, court. Update with pretrial within 24 hours of release. Pretrial has attempted to contact Mr. Metz to make him compliant with his release. He's not returned a phone call.
Your Honor, I never received any calls from them. I have called them multiple times and I reached the recording line stating that the MCR line for District 40 is unavailable. I left my name, my updated phone numbers, my address, and never received any call back. And I've called 3 different times. I did keep with the 24-hour curfew, only left for work and have been home ever since.
So she checked the voicemail and there wasn't a voicemail. left.
I have a record of it on this phone before I got this number of me calling and stuff.
Yes,
Yes,
what is this?
Probated sentence, Your Honor.
What was the charge?
Possession.
Okay. I'm gonna give you the benefit of the doubt.
thank you, sir.
On a plea of guilty, the Commonwealth makes the following recommendations. Guilty of possession of controlled substance, first degree meth, he will receive a sentence of 3 years, probated for 5, probation to be supervised. Drug paraphernalia and contraband should be disposed of. What are the court costs involved in this?
$240.
$240. You need some time on that.
I can pay it tomorrow after my next job.
Well, you don't have to pay it all at once if it puts you in a hard situation.
I can do $50 a month if you'd like
Okay,
that,
your
sir.
First payment could be due 30 days from today.
Alrighty,
And you pay $50 a month fixed pay. You need to meet with the probation parole officer over there. And he's sitting right over there at the desk, and you need to make sure you're compliant with it. And so you get this behind you, okay?
yes, sir.
Thank you very much. Brian Muse. Brian Muse. Looks like there's an active warrant, Mr. Stockton.
We'll put him in CIC.
Okay. Noah Neal. Commonwealth versus Noah Neal. Are you Noah Neal?
Yes, sir.
You born in 1998? Yep. What are the last 4 digits of your social security number?
8621.
8621, okay. You're here for a pretrial conference. What do you have?
Mr. Neal is currently in the special report program. He's doing very well. I anticipate once he graduates, I'll move to dismiss the skip.
Sounds like a deal and a half, Mr. Neal.
Sounds good.
Yeah, well, you work hard, finish that program. I'm gonna just continue it and let you redocket it. I'll just leave it up to Commonwealth to keep up your case. Still in the same conditions, bond not to violate and under conditions of drug court, okay? Thank you.
Thank you, Your Honor.
Charles Overshiner. Commonwealth versus Charles Overshiner. 23 CR 0049. Are you Charles Overshiner?
Yes, sir.
Okay, were you born in 1983?
Yes,
The last 4 digits, social security number 3485.
Yes.
Here today for the purpose of arraignment, you written by counsel. Mr. Poindexter. Yes, sir. Right to remain silent. Grand jury of Cumberland County has returned an indictment charging you with strangulation and the second degree assault and 4th degree. You understand those charges?
Yes.
Mr. Poindexter, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, and plea of not guilty, reserving all pretrial motions?
I do, Your Honor, except we have a plea agreement. Already.
Well, you need to step over inside.
Yes, sir.
No, this is giving a little background on this one. This is a case where the victim, the mother of the children in this case, she was allegedly assaulted by Mr. Overshiner. She didn't want to press charges. She testified at the grand jury that nothing happened, but the grand jury indicted Mr. Overshiner despite her testimony. Now, Mr. Overshiner wants to enter a plea with conditions so he can be reunited with his family. So if you want to enter that plea based on those facts today, the Commonwealth's prepared to proceed.
He has signed up for anger management counseling, Your Honor. Sorry, he's signed up for anger management counseling, Your Honor. Part of the plea agreement is also marriage counseling. He's wanting to take responsibility for his actions today and asking the court to go with this plea agreement. He has no criminal history, felony criminal history.
Excuse me, I got a bond call.
Yes, sir.
Well. Yes.
No, it's fine.
That'd be wonderful. I'll need to call you back because I'm on the bench right now. Could you give me a number to call you back? Give me the name. Susan, okay, I'll call you back in the morning, this morning. Okay, thank you. Excuse me. This is Mr. Stockton. This is a little unusual. I'm gonna go ahead and arraign him, which we already have done. And I want I want to go ahead and set up for a conference for negotiation. And then he come back next week, and I want you, there wasn't an EPO or a DVO or anything like that, you know?
Oh, you're right.
No, because basically, I wanted to form the pull what happened.
Yeah,
The children called the law because of the domestic violence. And of course, then there's pictures of her preserving and she will not cooperate. And I'll tell the court, Mr. O, we're trying to work the house and that's the kind of supervisor position. He's wife or son. So this is a complicated scenario.
I remember the case now from looking. There was some issues about modification of bond conditions or something like that.
Yes, sir. So that way they can both continue working. He's been there for how many years?
12 years.
And he has no criminal history, right?
Well, till now,
Yes, sir. Yes, sir.
and I'm gonna tell you, I'm not gonna take a plea on this today. I wanna like jog it around a little bit. As far as the conditions, I will change the conditions of bond where they can work at the same place. You're not, are you with her now? Are you living it with her again?
No, sir, I'd like to go home.
Well, I know you would, but
And she's here today, right?
that's good. That's good.
They've been together for how many years?
22 years.
22 years, you're right. And had never stayed apart until this incident. And,
Yeah, well, that's until he choked her,
yes, sir.
you know, or until he beat her. I just don't go for that stuff, man. You know, have y'all talked to her personally?
Ms. Ridge has dealt with her. She's testified at the grand jury. I don't think she was telling the truth. She testified at the grand jury. And that's just my opinion.
Yeah.
So.
Well, I want maybe,
So I would consider a non-cooperative victim.
yeah, why don't you let one of your assistant Commonwealth attorneys talk to her back there today before she leaves in private, okay? And I won't have a negotiation day. I'll just put you back on the docket for July the 27th to come back here. And I'll consider the plea between now and then. What kind of plea was it?
It was one of the 5 years of the burden on strangulation. He's got about 24 days on incarceration. He was gonna go to anger management counseling. They were both gonna have to enroll in marriage counseling. He's gonna be supervised. And according to Mr. Poindexter, the counseling can start from July the 28th. He has signed up for it when it starts.
Well, I want him in counseling before then. When he comes back here on July 27th, I want him to have been in counseling.
Or they don't have any dates. That's what the
Who's
council,
they?
Angel Arms.
Well, somebody else
Counseling in
does.
Glasgow?
Somebody else has got some somewhere.
Okay, he checked with Life Skills and Adonta and they didn't have anything either, so we weren't sure what to do. But we'll do our best, Your Honor, to get him somewhere.
Well, I want you to convince the Commonwealth between now and then that he's in anger management and that they're in kind of counseling. And I still don't want them together until we get this thing resolved. Okay, sometimes you have to protect people even when they don't want to be protected.
Yes, sir.
Okay, we'll see you back here on July the 27th.
Yes, sir.
Charles Perkins. Commonwealth versus Charles Perkins, 23 CR 0029. Are you Charles Perkins?
Yes, sir.
Born in 1981. Last 4 digits, social security number 9080.
Sir.
You're here for a pretrial conference. What do you have?
Your Honor, we are waiting on discovery in this case.
Yeah, the lab's not there. We can have to finish this. Get the lab back.
You want to what? You want to put it back on the docket yourself? Or
We just put it on for August. To get the lab, we'll set it on.
August the 24th. Okay, you're in the same conditions. Carla Rich. Carla Rich.
Well, there wasn't a warrant on the question. That was probation.
Okay. The warrant be issued. Was she served to be here today? Would you check the file?
I was of the motion,
That's what I mean.
to go straight from the coroner's office, so we probably.
Goes what?
Yeah, if Miss Sexton didn't get a warrant, then we mailed it to her last known address.
Okay. We'll have a warrant issued. I don't really want to put a no bond for FTA because I don't know whether she got it or not. You been in contact with her?
I have not, Your Honor, but if she didn't get, I don't have an updated phone number either, so. This case was a little older.
What was the probation violation allegation?
Well, she's had multiple failed drug tests and she's going to quit driving on a DUI suspended license.
Issue a warrant. No bond. Two things that really bother me when people are out on probation, 2 or 3 things that bother me. Driving under the influence or having a weapon. No good can come from either
She
one of
wasn't
those.
DUI, but she's driving on DUI suspended
Yeah.
license.
Yeah, well, she runs over somebody, she's got no insurance. John Scott. John Scott. There's
We'll put him
a,
in NCIC.
okay. Michael Scott,
Also, we'll put him in.
Tanya Scott. Commonwealth versus Tanya Scott, 18 CR 0059. Are you Tanya Scott?
Yes, sir.
Born in 1993.
Yes, sir.
Last 4 digits, Social Security number 1604.
Yes, sir.
You're here today from sentencing. Have you had an opportunity to review pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
Is there any reason this lady should not be sentenced?
No, Your Honor.
Tell me about the weapon involved in this case.
Your Honor, Ms. Scott was a co-defendant. This case is from 2018. Her involvement was lesser than the co-defendant. I think the plea agreement kind of reflects that. Additionally, all restitution was involved. I don't believe Ms. Scott was the one that possessed the firearm.
That's my understanding. There was a gentleman, another gentleman from Tennessee that Jimmy White presented that ended up paying all the fees. And I think he was the one that probably had a firearm in the back.
Did he enter a plea?
Yes.
He did this many years ago,
Yeah, it was more in time, I think in 2018.
probably about a year after the incident.
Okay.
I think he was in jail in Tennessee at the time too.
Okay, upon a plea of guilty to burglary 3rd degree, you shall receive a sentence of 3 years probated for 5 years. Receive credit for any time served. You'll pay court costs the amount of $215. Can you pay that today?
No.
Okay, I'm gonna allow you to pay it $30 a month, starting 30 days from today. You'll need to meet with the probation and parole officer. Are you a Tennessee resident?
Yes, sir.
So I guess you'll transfer her back down there. What you'll do. Well, you know, if you violate down there, they'll send you back up here. You understand that?
Yes, I do.
Okay. Mary Beth Stalker. Commonwealth, Kentucky versus Mary Beth Stalker, 23 CR 0038. Are you Mary Beth Stalker?
Yes, sir.
Were you born in 1983?
Yes, sir.
Last 4 digits, Social Security number 22. 2, is that correct?
Yes, sir.
Are you represented by an attorney?
No,
Okay. Did you fill out an affidavit? Do you have a job? Do you have any resources?
I work for my dad, taking my mom back and forth to dialysis.
Okay, well, I want you to fill out an affidavit over here to see if you're eligible for a public defender. You got an affidavit there? Do what?
He doesn't know what she's offering.
Okay, if you'll come around here, I'll come back to you. Chandra Warren. Commonwealth Kentucky versus Chandra Warren, 23 CR 026. Are you Chandra Warren?
yes,
You're for pretrial conference.
She has a coach named David Henry, who got that real extensively in Monroe County. And he's not been served, and I'd like to get him served before we proceed with this case. Either continue January or continue till August, see if I can get him picked up.
August, you'll be back here August 24th.
Call me at the beginning of August because we will set our,
What was his name, Mr. Hammer?
David Henry.
You know where David Hammer is?
I haven't seen him.
Gotten scarce.
Yeah, about the time I got indicted.
Cody Willis. Commonwealth Kentucky versus Cody Willis. Are you Cody Willis?
Yes, sir.
Do you have an attorney?
David.
Where is Mr. Poindexter? Mr. Poindexter? Yeah. You represent Mr. Willis? You represent Mr. Willis?
I've not been retained for circuit court, Your Honor, but I'll stand in for arraignment purposes.
Mr. Willis, are you going to retain Mr. Poindexter?
Yes, sir.
Mr. Willis, let me go over it again. You were born in 1989.
Yes, sir.
Last 4 digits, social security number 2394. You're here in 23 CR 0040. The grand jury of Cumberland County has returned into that one, charging you with possession of a handgun by a convicted felon, possession of controlled substance in the first degree, theft, unlawful taking or disposition of a firearm, possession of drug paraphernalia, criminal trespass, and being a persistent felon. You understand those charges? Mr. Poindexter, you acknowledge the identity of your client, received indictment, away formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
What is the bond in this case?
He says 10,000 property and he has an ankle monitor.
Was there a stay away from anybody? Do you know anything about this case?
Just what's in the place before.
Okay, it says no contact with the victim or victim's family. Okay, well, I want to tell you that I take your bond conditions very seriously. If you get around anybody, have any weapons on you, you break any law or something like that, you'd be in trouble. You understand that?
Yes, sir.
Okay, you come back here on the 12th for negotiation of July, and the next court appearance is the 27th. The bond conditions remain the same.
Mr. Poindexter is retiring, we need to contact our office, so we can send this.
I will. Yes, sir. I'll do injury repairs.
If you're not gonna get Mr. Poindexter, you need to get somebody else when you find out that you're not, because I expect you to be here with a lawyer on the 12th and on the 27th. You understand? Was she eligible? Yeah. Go ahead. You come around. I'm going to appoint a public advocate in this case. You fill this out. From here. And I'm finding on the affidavit she is indigent to an appointment. Okay, you are Mary Beth Stalkup, born February 23rd, 1983. Is that correct?
Yes.
Last four digits, social security number 2212.
Yes.
The grand jury of Cumberland County has returned an indictment charging you with theft to make required disposition. You acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserved in all pretrial motions.
Yes, Your Honor.
She shall be here on the 12th for negotiations. And the 27th for the next court appearance. Both of them are conditions of bond, okay? Thank you.
Thank you, Your Honor.
Hey, I guess we had Peyton Boer. Is Peyton Boer ready to go?
Your Honor, my office has reached out to her. We've not had any call back in.
So she's supposed to be some paper from yesterday. and she goes off yesterday.
She had an appointment Friday yesterday and I know she's been really ill. She's I know she's
Joshua Duval. We'll come back to Peyton Boer in just a second. Commonwealth versus Joshua Duval, 23 CR 0030. Are you Joshua Duval?
Yes, sir.
Born in 1985.
Yes, sir.
Last four digits, social security number 4641.
Yes, sir.
We're here for a pre-trial conference. What do y'all have?
Your Honor, we have a pretrial diversion agreement.
Okay. The motion's been tendered that says you wish to enter a plea today. Is that correct, Mr. Duval? Yes. Are you currently under the influence of drugs or alcohol? Are you under the influence of drugs or alcohol?
No, sir.
Will you move over and let him behind the mic?
No, sir.
Is the plea freely and voluntarily given?
Yes.
Are you the same person? Named indictment number 23 CR 0030.
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you?
Yes, sir.
You believe you've been fully informed?
Yes,
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against yourself. No one can make you say anything. Right to speak trial, the jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to acquire the Commonwealth through unreasonable doubt that you're guilty of charges against you. Understand that. Any guilty plea, that you give up all those rights. Understand that?
Yes, sir.
I'm gonna consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Then I do not accept the recommendation and decide to impose a harsher sentence. You have the right to withdraw your plea of guilty and proceed to trial. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felony convictions in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you not complete the diversion program, the charges, if you do complete the diversion program, the charges would be dismissed. You understand that?
Yes, sir.
You understand that if you do not completely complete the diversion program, you brought back to the court now void your pre-trial diversion, you would be sentenced as a felon. You understand that?
Yes, sir.
Please take a step to the left. What is the Commonwealth's recommendation? Ms. Gordon Anderson.
Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500 plus court costs. The defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall pay fine at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky and shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agreed to, Mr. Duval? Is that what you agreed to?
Yes, sir.
Okay.
And Your Honor, I just wanted to, I've spoken to Mr. Stockton about this as well, the no insurance charge. Mr. Duval believes that he provided proof in district court as to that charge, but we could not locate it in the file. Mr. Stockton has no objection if he were to provide proof again to amending the judgment and removing that charge.
Your Honor, but this is sprung on me at the last minute, and I've had people furnish proof of insurance, not anything against Mr. Duval, bring forward, and out of date, everything else, so I always verify when I get it.
Yes.
I've not had an opportunity in this case.
Are you pleading guilty because you committed the acts charged in the indictment, subject to the reservation and determination about the insurance?
Yes.
Yes.
He said subject to that
Okay, yes,
reservation.
yes.
You know your constitutional rights is still your desire to proceed with the plea. Allow me to fix the punishment.
He's asking you if you want to proceed.
I've
Yes.
explained to you what your rights are. And
Yes.
knowing your constitutional
Yes.
rights, which you say you've already done, is it your desire to proceed? Let
Yes.
me into the punishment. Okay, is that your signature on the motion?
Yes, sir.
Okay, I will give you the close of business today to prove the insurance to them, give them the name and y'all can verify it. If they do that, I will sign the order. Okay. If he's not telling the truth about the insurance, the whole deal's off as far as I'm concerned. You understand what I'm saying?
I understand
And
that.
we'll schedule him on the pretrial and in the next court date. Okay, what are the costs?
With $500 and $750.
Okay, it's $250 if you have the insurance, $750 if you don't have the insurance. Okay, if you don't have the insurance, you don't have a deal anyway, so we're coming back. Okay,
Yes, sir.
you need to meet the probation parole officer over there. What do you end up doing with Kenneth McIntyre?
He's like going to be processing ready.
Okay, Kenneth McIntyre. Kenneth McIntyre. Commonwealth versus Kenneth McIntyre. 23 CR 0046. Are you Kenneth McIntyre?
Yes, sir.
Were you born in 1999?
Yes, sir.
Last 4 digits social security number are 0538.
Yes, sir.
Mr. Duval, you know to go get that proof of insurance now, don't you?
Yes, sir.
Okay. You're here today for arraignment. You have a lawyer? Did this go through district court?
Yes, sir.
Did you have a public defender in district court or did you have a lawyer?
I have a court-appointed lawyer.
Okay, I'll continue that appointment. Here today for the purpose of arraignment, this is your lawyer here standing next to you. The grand jury of Cumberland County has returned an indictment charging you possession of controlled substance, possession of drug paraphernalia, and possession of marijuana. You acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, and plead not guilty, reserving all pre-trial motions.
Yes, Your Honor.
You'll be back here on the 12th of July for conference negotiation. And the 27th is your next court date. Both of those are condition of your bond. Now, where have you been? Why did you just show up today?
I'm on ankle monitor. I've been home and at work and I didn't know nothing. Nobody called or nothing. I didn't know it was even an indictment. I just knew I had a court date for the court docket.
Okay,
Yes, sir.
You've been
So-
on an ankle monitor
Yeah,
since district.
I'm on the ankle monitor right now.
oh, that's okay.
So,
Okay, you're good.
all right, thank you. Mhm.
Sorry, you're welcome to junior.
Now we have the issue of Peyton Boer still. Okay, go downstairs. Wait just a second, sir. Just have him sit over here somewhere till she posts the bond, okay?
Okay.
He's got to sign the bond too, doesn't he? Do we have an extra bailiff here? Won't you walk him downstairs and let her post the bond? Okay, how many people we have down at the front desk? How many bailiffs do we have downstairs? How many? Okay, we'll have one come up here and when you and you go down there and tell him what's going on with his bond. I'll let him walk down there with you. Okay.
Jeremy Curtis, you can call his name, he wasn't here, he has acted, he showed up like inspectors as well.
Jeremy Curtis. We'll just call him in a minute. Wait just a second. We'll just wait a second. We'll call him in a minute. I'm gonna go ahead and do these remote locations here. He didn't get here. He just wait back there. Barron County Detention Center, are you on there? Barron County. Barron County Detention Center, I see you on there.
Here, Your Honor, I'm trying, I'm sorry.
Okay.
There we go.
Thank you. Commonwealth of Kentucky versus Robert Stevenson. 21 CR 00113 and 21 CR 00126. Are you Robert Stevenson?
Yes, Your Honor.
Okay, we're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Stevenson has a 7-year, 6-month sentence.
Well, you'll have to get over here so we can hear you. Okay.
He has a 7-year, 6-month sentence for receiving stolen property. He owes $2,000 restitution, which he had been paying on somewhat. He had a positive test for fentanyl, and Mr. Collins, who's on vacation this week, sent him to a type of rehab. I can't remember if it's Sapope or rehab. He completed that, and then when he got out, he had a positive meth test. So that's the reason for the revocation.
And I believe Mr. Stockton would be okay with a referral to drug court to see if he would qualify, because
I spoke with Mr. Collins while he was on the beach yesterday. He said that would probably be all right with him if that's what the court wanted.
Let's do a referral. We'll just keep him where he is now for his own protection.
Yes.
Have him come back here on the 27th. Is that right?
yes,
And if we get accepted in the drug court and get him oriented or anything before then, we'll take a look at it. Are you willing to try drug court, Mr. Stevenson?
Yes, Your Honor.
Okay, well, we'll go ahead and do a referral. If we can get you lined up, you get accepted and we can get you doing, I'll agree with that since the probation parole officer called up here about it. If not, you'll be back in court on July 27th.
Thank you, Your Honor.
Okay, we have, did y'all have Edward, Whitledge over there?
Yes, sir. Yes, sir.
I have a ex parte motion on
Want me
him.
to go get him?
I'll need him, but I'll need him in a different sort of way. We're gonna have to make this opportunity. This will have to be privately done, so you'll have to do, what do you call them, side rooms or whatever, that do it like that.
Okay.
Okay,
We also have one motion, Your Honor, that should be just on the regular docket from Mr. Whitman.
come on up here. Could you bring Mr. Whitledge up now?
Yes, Your Honor. This one's ready to go back and I'm gonna need Ridley, please.
This is Monroe Circuit Court, case number 20 CR 0085. Come up, thank you, versus Edward Whitledge.
Good morning, Judge.
Good morning.
Good morning. Judge, we filed a motion to transfer Mr. Whitledge to a different jail. My understanding is the Commonwealth has no objection to
Is
this.
the Commonwealth here?
Mr. Stockton.
You're in this, there's not a special prosecutor in this case? What's the basis for that?
Judge,
Let's wait till we get him up here, okay? He's on the way up. There- I'm gonna have to find some, obviously, the Commonwealth is entitled to notice that this part of the motion has been filed, but they're not able to participate in that, but I would assume you want that on the record, so I'll have to figure out exactly how to do that. Here.
Your Honor, we would waive Mr. Whitledge's appearance for the ex parte motion if that would make that easier.
Probably would. We'll just have to tell him that and see if he agrees to that.
Right.
See, I don't see Kenton County on there. Could you see, somebody see if they get a hold of Kenton County Detention Center? Rotor, are you on there? Rotor Correction Complex?
It don't matter.
Okay, are you Kenneth Rutledge? Kenneth Edward Whitledge, excuse me.
Yes, sir.
Okay, your attorneys are here present today. They had a motion that they wanted to file to move to another correctional institution. Now, could y'all give me some reasons for that?
yes, Your Honor. So Mr. Whitledge's charges are very serious in nature, and there has been a lot of local publicity.
I can't
So,
hear you, I'm sorry.
so due to the serious allegations that Mr. Whitledge is facing and the local publicity, I think that bleeds into some of the antagonism he has received at the jail, involving threats to his person. And a lot of these things, when we're talking about inmates threatening other inmates, a lot of that has gone undocumented. In our motion, we did cite a specific incident that happened during a court hearing in January, actually, where Mr. Whitledge was brought to the camera. And in the background, you can hear another inmate saying, you might not want to bring him in here. You might not want to bring him in here. And so I think that incident provides the court with at least some documentation that these threats are real. And so and there's a probable danger to him. So we're asking the court to intervene before that becomes an actual danger, where there is some sort of incident that could harm Mr. Whitledge or jail staff trying to separate inmates. And we listed the Hart County Jail as an option. I think the statute.
Let me call somebody from the Barron County Jail here to get a report. Is there anyone present that can talk to us about Mr. Whitledge's safety?
Yes, I can get you the jailer.
Okay, that'd be great.
300. Judge Williams from Cumberland County is requesting to speak with you in the courtroom. He's on his way, Your Honor.
Thank you.
You're welcome.
Hey, how are you today?
Morning, Your Honor. How are you?
I'm blessed. Thank you for coming up. We have some attorneys here that represent Mr. Edward Whitledge.
Yes, sir.
They have filed a motion seeking to transfer him to a different institution, saying that they feel like he might be in some danger because of the type of his a charge against him in Monroe County. Have you experienced anything or had any complaints from him or anyone else concerning his safety? And do you believe you can secure him or separate him if he does have a safety situation?
Yeah, I've got him separated now, but I haven't had any issues with anybody approach me about him.
Okay, now how do you, for their edification, what kind of separation do you have for him?
I have him in a medical cell up front. He is in there with another gentleman that he is had suffered a gunshot wound to the head and is paralyzed pretty much on one side. Have no disciplinary complaints with the other gentleman either. But
okay, would y'all like to inquire of the jailer anything?
Go ahead. Well, Your Honor, I would just state that the
You need to
cell,
speak up, son, for him to hear you.
Mr. Whitledge is being held in isolation. Is that correct?
no, it's in a medical cell.
I'm sorry?
In a medical cell. He has all the entities that they would have in a regular cell.
Okay. Is it built for one person or two?
Built for one, but we have two in it, just like our population cells back here are overcrowded also.
And how many times a day is Mr. Whitledge being taken out of the cell and given recreational time?
That part, it's not done daily because we have one rec area and we've got multiple cells in here. I'd have to actually go back and count exactly, see how many cells we have.
How often is he supposed to be being offered recreational time?
Well, hello.
Here, wait a second. We're not here to criticize the overcrowding of jails. You brought up the fact that you thought he was in danger because of nature.
Yes.
I'm satisfied with the fact that he's not in danger, that he's being protected and he is with another inmate there in probably a better condition than if he was in the general population as far as undercrowding is concerned. So if you want to ask him anything else, or if you have any more specificity, I'm going to overrule that motion right now to move him.
Well, Your Honor, I don't think that holding him in isolation is the answer.
He's not in isolation. He said that he was in a medical cell with the same amenities that he would have in any other cells, what he said. He's in
a
and that
one-man
he's
cell.
overcrowded. So I'm
Right.
overruling your motion, and you can certify it and take it up if you want to.
Well, there was one additional issue in the motion that we hadn't addressed yet, Your
Go
Honor, if I
ahead.
may.
Go ahead.
The other issue is the medical treatment that Mr. Whitledge is being denied in Barron County. We've provided documented proof of his mental health diagnosis and his prior medication history to the Barron County
What
Jail.
medication you want him to receive?
We want him to be seen and medicated for his bipolar disorder with whatever medication is appropriate.
Have you taken him to the doctor over there about they allege he's previously been diagnosed with a bipolar situation. Has he seen a doctor? Has he taken any medications, Mr. Jailer?
Now, I've had to check with my medical on that. They have my medical takes care of all the medication and doctor visits and stuff. I couldn't answer to that.
Okay, if you'll provide us a written answer as to what kind of medication he has there, and we'll provide it to his attorneys, and then we can take this back up separately. I'll reserve any order on that, okay?
Yes, sir.
Thank you very much for your cooperation. I don't think we have anybody else over there until we get into the regular docket, which won't be, I guess that's it for you. Do y'all have anybody else over there to see us? Probably not. Okay, now, I'd like Mr. Whitledge to come back around. Let me say one thing. I think, Mr. Whitledge, we have a motion up here that's to be held. It's an ex parte motion, which means that it'll just be your lawyers and me present on the record, and they said it's all right to waive your presence. Is that okay with you? You've discussed this motion with them. Are you okay with not being online when we have this motion? Okay, thank you very much. And thank you, Barron County, for your cooperation.
Yes, sir. Yeah.
You're excused.
Thank you.
Thank you, Your Honor.
Okay, now, did anybody check with Kenton County or Roder? Roder, are you on there?
Schroeder's on their way to get on. Mr. Bricker's unit was on lockdown, but they've been released from that and they're getting on as soon as they can.
Okay, and what about Kenton County? Okay, Mr. Garner's on the phone with him.
King County said that nothing was scheduled with them, Your Honor, and that they don't have the personnel available to accommodate Mr. Danny. They asked if they could continue it until they can get a.
Let's do it since it's where are we at next week?
Have courts.
Next week we don't.
We don't have courts. Clinton County on July 13th.
Let's schedule it. Tell them we'll send them a notice for July 13th. Okay. Did you hear that, Megan?
Yes.
We'll have that heard in Clinton County, the next rule day we have over there. Okay.
Your Honor, I don't know that I'll be appointed to Mr. Stewart, but given that he's in custody, a lot of times it does happen. Could I appear via Zoom, or would you want me there in person? I can accommodate either one for the court.
Well, need to be there in Zoom, but let's take a look at him and see. Do we have an affidavit on him?
No, sorry.
Okay, well, let's see if you can get them to do an affidavit. And I'll go ahead and do the appointment.
Okay.
And that way you can consult with him by Zoom or whatever, and we'll let him be around in Clinton County.
Yes.
Okay, I'll continue the appointment.
Okay.
Okay, I'll just continue the appointment. Now that has us down to the gentleman that came in late, I guess.
And then Mr. Ronnie Anderson, I was a little some paperwork.
Yeah, I missed that. But type of note right. So
Okay.
And then Peyton Brewer.
Peyton Brewer, we don't know yet.
I've reached out.
Jeremy Curtis, is that who it is?
I see Roder on here now. Let's go to Roder. Okay, Roder, Correctional Complex. Paul Bricker.
Mr. Bricker is not yet. It's in my office, sir.
Okay. Well, just leave your microphone on when he comes in there. I'll take you at the first thing, okay?
Yes, sir.
Yeah. What do you have? So you're doing Ronnie Anderson right now. Who do you have in the back?
Jeremy Curtis.
Come up versus Jeremy Curtis, bring him on out. Yeah, I'll take this Cumberland County case up. Commonwealth versus Jeremy Curtis, 23 CR 0047. Are you Jeremy Curtis?
Yes, sir.
You born in 1979?
Yes, sir.
What are the last four digits of your social security number?
9067.
Did this go into district court? Are you in district court?
Yes, sir.
Who represents you there?
Samantha, I think.
Yeah, I'll continue the appointment. She's here. You're here today for the purpose of arraignment. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in first degree methamphetamine, possession of drug paraphernalia, failure to produce insurance card, and failure to use seatbelt.
Bricker.
Here's Jake Porter for you.
My name's Joey.
Other charges. You acknowledge receipt of the indictment, identity your client, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Where have you been this morning? It's been out for you.
I've been with my daughter.
Where is that?
Glasgow, Kentucky, sir.
Yeah, okay. What's the bond on this, you know?
15,000.
Okay, the bond is 15,000 surety. Okay, you be back here on July the 12th for conference and July 27th for the next court appearance. She's in the custody of jailer.
Your Honor, I would ask the court to consider carrying over his bond from district court. He posted 2,500 cash.
His possession case, I have no objection.
We'll allow you to do that. Carry his bond over, okay?
Thank you, Your Honor.
But I want the same, I want a curfew on him.
Okay.
You know, I want you to home, church, doctor, or that sort of thing. Are you working anywhere?
Yes, sir. I
Okay,
work for
well, I want
myself.
to continue to work, okay?
Yes,
Let's
sir.
go to Roder now. Commonwealth, Kentucky versus Paul Dricker, 22 CR 0094. We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor,
We'll need to get up here so he can hear you. Okay. Okay,
We'll need a trial date on the case here in Cumberland County.
okay. Who represents you?
I do, Your Honor. I'm sorry. I'm trying to do too many things at once. I apologize.
What is it? What are you going to try? What are the charges you've elected to try?
the charge of this and that.
All what?
All charge of this and that.
I don't have that with me. That's what I'm asking.
Okay, there's 6 of each charge.
Okay. Okay, you need 2 days to try it.
I would think so. How, Mr. Bricker.
You need to get over here so he can hear you. Wait just a second.
Mr. Bricker is state inmate. And because of the trial docket and everything we have, because we have some time maybe in October.
Well. How long is your sentence? How long is your sentence up there?
It's 6 or 7 years.
I think it's 7, Your Honor.
We need to go out further. I know August is pretty full.
Yeah, it would be hard to do it in August. I did.
How about September the 12th?
Somebody in my office, I'd kind of like to be on this case. I'm gonna be out that week. That's one
Okay,
reason I
let's
said
go
October.
to another week then. How about September the 19th?
That looks fine with me.
I can do that, Your Honor. Your Honor, since it is going to be a 2-day trial, that would be Tuesday into Wednesday. Would that be a problem with the courtroom with?
No.
Okay, I just saw that on my calendar.
Mr. Brigger, we got a trial set for you on the 19th and 20th of September, okay?
Yes, sir.
Your attorney will be in contact with you as far as preparation or any motions that be made in discovery or anything. Roder, thank y'all for cooperating with us, and you're excused, okay? Okay, now still got somebody here. Yes, Mr. Curtis. We did Mr. Curtis, and so we got Ronnie Anderson.
Waiting on paperwork.
Waiting on that. So let's go to the Adair County Jail. Adair County. Adair County, will you turn your mic and camera on? Okay, Adair County, Timothy Alexander. Timothy Alexander.
We wanted to report on Johnny Duval. He knew that. So we'll be in the take out.
Okay. Thank you, Mr. Duval. Commonwealth versus Timothy Alexander, 19 CR 0042, and an arraignment on 23 CR 0039. What we got? Are you Timothy Alexander?
Sir.
Born in 1982.
Yes, sir.
Last four digits, social security number 5227. I'm going to do your arraignment first. You've got a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with assault in the first degree. Who's representing him in this case?
I am on the arraignment, Your Honor.
Okay. You acknowledge the identity of Mr. Alexander, Mr. Bailey? Thank you. You acknowledge the identity of Mr. Alexander, received indictment, waive formal reading and arraignment, and pleaded not guilty or voting all pre-trial motions.
I do, Your Honor.
Okay. We'll set, revocation, pre-trial diversion revocation. Are you representing him on that?
I'm not, Your Honor.
Yes. And on the revocation action, Your Honor, because it is the underlying issue with the revocation is the new charge. Spoke to Mr. Stockton, and I believe everybody was in agreement to pass this for a settlement day.
Yeah, I don't think I can proceed with the revocation. I just filed it because he got the new assault charge and we have to.
Well, I really don't think, Mr. Poindexter, I think you need to take both of them if you're going to take the lower one, because they're intertwined with each other. So I'll relieve public advocacy. Mr. Alexander, they're going to have an opportunity to discuss this with the Commonwealth on July 12th, and you'll be involved in that discussion. Mr. Poindexter will be in contact with you, and you'll be involved in that negotiation with these two things together. And parents will be on the 27th of July. Okay.
All right.
Okay. Thank you very much.
Your Honor, could we address this bond? Your Honor, I'd like to ask, from my understanding, and
file a motion in a case with this kind of serious allegation.
Yeah, I'd like to have an opportunity to have the appearance issue.
Yeah, and I can do that before the next date if you want, if you feel like, if the Commonwealth feels like there's a hearing necessary.
Yes, sir.
Okay, thank you.
Thank you, Your Honor.
Jason Bailey. Commonwealth versus Jason Bailey.
Good morning, Your Honor. Robert Stevens for Jason Bailey.
Commonwealth versus Jason Bailey. 21 CR 0020. Are you Jason Bailey?
Yes, sir.
Born in 1977.
Yes, sir.
Last four digits, social security number 9002.
Yes, sir.
for a pretrial conference. What does the Commonwealth have to say?
It was just picked up in NCIC and we need to
Come over here so he can hear you.
Yeah, we need to have a pretrial negotiation day and I don't think Mr. Stevens has seen him in quite some time.
I spoke to him this morning, Your Honor. I was not aware he had been picked up.
July the 12th for the negotiation day and July the 27th for the next court appearance. He's on no bond right now, is that correct? Make it no bond. Zachary Bramlett.
Thank you, Your Honor. Could I be excused?
Sure.
Thank you, sir.
Zachary Bramlett. Commonwealth versus Zachary Bramlett, 23 CR 0001. Are you Zachary Bramlett?
Yeah.
Okay, you're represented by Mr. Cross. Mr. Bramlett, were you born in 1992?
Yes.
Last four digits, social security number 8719. We're here today for a pretrial conference. What does the Commonwealth have to announce?
Your Honor, we actually had a plea in this case and he was set for sentencing and he picked up new charges before the sentencing. So if the court sets aside the plea, either we need to work on another plea or set a trial date.
Has he entered the plea yet?
He entered the plea, yes, sir.
Yes, Your Honor, you rejected it in May at the motion day. And it was because he had these additional charges in Nelson County. And I think we'd like to get this one done, but we'd like to deal with Nelson County and be sure that the pleas complement each other and.
Was he here today for sentencing or what?
No, there is no, I would just suggest that we get another pretrial and a negotiation day and try to coordinate the plea with Nelson County.
Yes.
So I didn't accept the plea. He didn't
would not
enter the
accept
plea.
the
There was a proposed plea.
3
That's
years
correct.
probate, it's what we
Yeah.
had. You
Well,
didn't.
it was accepted at the time, and then he got the new charges prior to sentencing, and then it was rejected.
Okay. So you schedule him for the 12th for negotiations and 27th for the next court appearance.
Thank you.
Mr. Bramlett, they're going to try to get your stuff in Nelson County and here all worked out together. So they'll be negotiating with you and
All right.
on the 12th. Okay, thank you.
Yep.
Shelley Crabtree. Commonwealth versus Shelley Crabtree, 22 CR 0068. Are you Shelley Crabtree?
Yes, sir.
Were you born in 1972?
Yes, sir.
Last four digits, social security number 6623.
Yes, sir.
We're today on a pretrial diversion revocation filed by the Commonwealth. What's the Commonwealth have to say?
Yeah, Your Honor, she has a 3-year sentence possession of controlled substance. She was terminated from specialty court on October 27th of 22 for absconding and excessive drug tests. My understanding is she's going to stipulate.
She does stipulate to those violations, Your Honor.
Okay, I will revoke a pretrial diversion, order a pre-sentence investigation report to be done by probation and parole. And let her be here for sentencing on the 27th of July. Mary Cresilius. Mary Cresilius. Commonwealth versus Mary Cresilius, 16 CR 0082. Are you Mary Cresilius?
Yes, sir.
Born in 1991.
Yes, sir.
Last four digits for your social security number 6262. We're here on a shock probation revocation. What do we have, Mr. Stockton?
Your Honor, she has a 7-year sentence, and according to reading through the violation report, 10-year, I'm sorry, it's got a 7-year and a 3-year sentence, make a total of 10 years. She's had multiple failed drug tests. She's went to 2 different treatment centers and absconded. The last time she absconded, she was picked up on June the 8th, and she was positive for meth and marijuana. So we're asking that she be revoked.
Your Honor, she does stipulate to those violations. She would like to tell the court why she had left treatment. Her it was because her mother had cancer, Your Honor, and she understands that she's messed up, but she would just ask the court to give her one more opportunity at treatment. She does have a 9-month baby at home, 9-month-old baby at home, and she just wants to do better, Your Honor.
Commonwealth can only say that she's had, this is not a probation revocation, this is shock probation. She's had multiple opportunities to get her life straightened out, and she hasn't. And it really disturbs me that if she couldn't get her life together when she had a little small infant. So I don't know why she deserves another chance.
I'll let her testify. You raise your right hand, please. Swear the testimony about to give us the truth, the whole truth, and nothing but the truth. Somebody got their computer on me. Causing them. Okay, go ahead.
Ms. Crecelius, can you state your name for the record?
Mary Crecelius.
And can you explain to the court why you had left treatment the last time?
The last time I left treatment was because my mom had got cancer. So I was in there for a month, and one day I left treatment because I called home. My mom's cancer had came back, and I left, and then I ended up getting pregnant. I didn't want to have a baby in jail, and then I had her every day. I'm just asking for some kind of help. I would really like to have a treatment where I could take my baby with me. I would even agree to pay for an ankle monitor put on while I was in a treatment center.
Yes. And so it's your wish to have your child with you while you're in treatment. Is that correct?
Yes, ma'am.
And Your Honor, I can tell the court there are treatment facilities that would allow that given the child's age, that are long-term facilities. Nothing, no further questions on our behalf.
You want to come over to the microphone here? Thank you.
Ms. Crecelius, it appears you hadn't reported to your probation officer since July of 21. Where were you during all that time?
Like I said, sir, I got pregnant, and then I guess I was just scared to have a baby in jail. I mean, that's why I didn't report to my officer.
You didn't answer my question. Where were you?
Where were I? I was home.
Where was home?
I'm Bowling Green, Kentucky.
Did she have a drug test when they picked her up?
Yeah, she was positive for meth and marijuana when they picked her up June 8th this year.
Okay. I'm going to revoke the shock probation. We'll let the parole board deal with it, see what they want to do. Thank you very much. Sonia Gross. Ground for revocation is that she's violated all the previous and refused to submit herself to the authority, and I think the child is probably in danger too. She's out there taking meth with a 9-month-old. So. Sonia Gross. Commonwealth versus Sonia Gross, 21 CR 0076. You're here for sentencing, Ms. Gross. You understand that?
Yes.
Hey, do you have an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes.
You had 2 years and 11 months pretrial diverted for a period of 5 years. Is the counselor, is the pretrial diversion, is the pre-sentence investigation report substantially correct?
Yes, Your Honor.
Is there any reason why the lady should not be sentenced today?
Your Honor, we would ask the court to not sentence Ms. Gross to serve the remainder of her sentence and instead place her on probation. We understand that the pretrial diversion was voided. She has served 180 days total in custody, Your Honor, and the last of that was 62 days since this motion was filed and until today. We would ask that to count as a sanction, Your Honor, and to give her another opportunity at probation. Being a convicted felon is a significant punishment, and the amount of time served. We would just ask the court to give her one more opportunity.
Mr. Stockton, you will come around.
I work with opposing probation based on the fact that we had an NCIC in order to apprehend her back on September 22nd of 2021. You know, it's not fun chasing after people. And if they would comply and show up, they'd have half the battle won.
I'm gonna sentence her to serve her term 2 years and 11 months. She's absconded and failed to comply in any other action. Okay. Robert Hernandez. Robert Hernandez for sentencing. Commonwealth of Kentucky versus Robert Hernandez, 23 CR 0018. Are you Robert Hernandez?
Yes, sir.
Born in 1962.
Yes, sir.
Last four digits, social security number 8881.
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor, this is a 1-year sentence and Mr. Hernandez has 128 days of credit towards this and he would like to move forward and get this situation behind him, Your Honor.
Mr. Stockton?
Yes.
What do you have to say about this?
Well, when we had our negotiation conference, he wanted to serve 1 year, so.
And he still does.
I accommodated. I'm still opposed to probation.
Well, this is what the agreement was.
Mhm.
On plea of guilty possession, controlled substance of meth, he shall receive a sentence of 1 year to serve. And he's probably, how much time is he having in?
128 days, Your Honor.
He'll be out in no time.
He is being held, he's got some charges out of Wayne County, Your Honor, but they're older, so.
Okay, thank you very much. Court cost is $185 and I will allow him to pay that $30 a month on 30 days after his release from incarceration. Lance Humphrey.
Your Honor, that's a motion for competency here, and Mr. Humphrey's not going to stipulate what competency. We have the doctor lined up at 12 o'clock Central Time.
Yes.
Okay, we'll call Mr. Humphrey back at 12 o'clock Central Time. Mr. Humphrey, when the doctor gets on the line, we'll call you back up, okay?
All right.
Ebony Klonsky.
12 o'clock.
Are you Ebony Karonsky? Is that how you say your last name?
Kazarowski, yes, sir.
Kazarowski. This is 21 CR 0016. You born in 1981, ma'am?
Yes, sir.
Last four digits of social security 5900.
Yes, sir.
The Commonwealth has filed a motion on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, if I may, I apologize. Ms. Kazarowski was represented by private counsel yesterday, and so I did not speak to her about.
Mr. Cross is need to get him.
Okay.
Get Mr. Cross if he's back there. Opening all those doors back there. I like the table, the tiger behind one of the doors. Yeah, Ebony Kazarowski.
Yes, you are. I'd rather say Ebony. I always mess up the name.
Yeah, me too. Pretrial diversion revocation motion.
Yeah, yes, Your Honor. It's a trafficking controlled substance 3-year sentence. Her violations are she had a positive for methamphetamines She also had a new felony arrest where she vandalized Andrea Anderson's house. Miss Anderson doesn't want to press charges, so that case is not going to the grand jury.
And it has been officially dismissed.
But she did admit to the violations to Mr. Garner that she did do this. So that's where we are.
Your Honor, Mr. Stockton and I have had some discussions on this case.
You need to speak up.
I need to speak up? Okay. Mr. Stockton and I have talked about the case at length. Ms. Kazarowski's ultimate goal is she's finally decided Cumberland County's not the best environment for her, and her goal is to return to her mother's home in Washington State. Now, there's some logistics on that about will they accept her? I think they will, but they don't have to if she has a home there. My suggestion, Your Honor, is let's just let her out, put her on whatever kind of
It's
monitoring.
always your suggestion for your clients is to let them out.
Your Honor, I think my suggestions are generally pretty reasonable because after 39 years of experience, I understand that we're not going to give her a medal and send her home. And what I'm trying to do is resolve this in a fair manner.
Give me the violations again.
She had a positive meth test and she went in, I think she was probably intoxicated or high at the time. And I don't know, opened up sinks and did water damage and basically
it's
vandalized the
underlying.
house.
Yeah, what's underlying?
Is a trafficking case, 3-year sentence. Now, Mr. Garner says that he can apply for the transfer to Washington. My suggestion would be to leave her in custody till next month as a sanction and let him go ahead and submit the paperwork to Washington, D.C.
I think that seems like a good resolution.
Well, of course, I'd prefer to get her out today, but I'll have to abide by whatever the court's
once we
ruling. As long as Ms. Kurzowski knows that I'm advocating on her behalf.
Ms. Kurowski, we're gonna try to get them to accept you up in Washington so you can leave this abode that you have here. And you're gonna be held till next to the 27th.
I say something, Your Honor.
Careful what you say, Ebony, only something constructive.
So the 27th of July, you'll be here unless, if they'll accept you before then.
I don't think it'll probably take longer than July
It
the
takes a while.
27th, but I think we probably let her out on a sanction on the 27th.
Yeah, well, we'll review it. In all probability, you will be released on the 27th on a sanction the Commonwealth has, and they'll start working on getting you transferred to Washington, okay?
Ebony, do you have something necessary and constructive to say? If not, don't
Well,
say anything.
Ebony's finished for today. So, thank you very much.
I'll be in.
Okay. Scotty Lake. Commonwealth versus Scotty Lay, 22 CR 0018. Are you Scotty Lay?
Yes, sir.
Born in 1967? Born in 1967?
Yes.
Last 4 digits of social security number 3701.
Yes.
You're here today for the purpose of arraignment. You are entitled to a public advocate. I'm going to appoint them to represent you. You're here for arraignment. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of a controlled substance in the first degree, operating a motor vehicle under the influence, possession of drug paraphernalia, possession of marijuana, driving on suspended operator's license, failure to maintain insurance, improper equipment, license plate not legible, careless driving, and being a persistent felony offender as to the tampering with physical evidence. Sir, you understand those charges? You have a right to remain silent, but you understand those charges?
Yes. Yes.
Counselor, you acknowledge you identify your client, receipt indictment, wait for more reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Set this for negotiation date on the 12th and the next court appearance on the 27th.
When's the next court appearance?
The 27th of July, but you have a conference date before then. Your attorney will be up to see you soon. And
Okay, now, I was out on bond on this, and then they come and served indictments, and brought me to jail, me and my girlfriend. So can we be back out on our bonds?
what is the bond?
It was 3%, 10% of 3,000, and they owe.
Wait a second, sir. What is this bond?
What was it? I'm sorry.
50,000 cash, she says.
I think what he was saying is that he had made bond in district court, but I couldn't understand if it was a cash
Yes.
bond.
Yes, I made bond. I've been out on bond, and then he come serve the warrants on it.
Okay, Mr. Lay, they're checking on it. Hang on.
I'm checking. that. Wait a second. Let me check on it. 10%. Yeah, I'll continue the district court bond. It was 3,000, 10%. I want a curfew on it. I want you to go to work, church, doctor, home, that sort of thing.
Thank you.
Do you work anywhere, Mr. Lay?
I'm trying for my disability right now, sir.
Okay, well, you'll just need to stay at home and do those presentations, and I'll honor that district court bond, okay?
Thank you. Your
Okay,
Honor.
now,
Mr. Lay, can
Yes.
you provide a phone number, please?
931 310 1111.
Okay, and they have my,
Wait a second. He's a Tennessee resident.
I think that was the purpose of the cash bond
Okay,
originally.
so I want him to do sign a waiver of extradition back up here. You agree to
Okay.
come back up? You
Yeah,
sign-
it's in Salina. It's in Salina, sir.
Yeah, well, that's as much in Tennessee as Memphis is, so coming across the state line.
Okay.
So you get him a document up there and can sign a waiver of extradition. They'll get you a document up there and I'll let you out today once you sign the document.
Okay, now my girlfriend's on the same case here, and they OR'd her. Now, she didn't have nothing to do.
What's your girlfriend's name?
Sarah Page. She'll be up here in a minute. And
Okay,
I'm taking
Mr. Lay, don't say anything
I'll
else.
do my best to.
Okay.
She on the bond too. Maybe y'all can ride home together today.
Thank you, sir.
Okay, thank you. Tang Lu.
No.
Counselor, you gonna get him one of those forms up there?
It's gonna be sent, Your Honor.
Could you state your name for the record, please?
Tang Lu.
Okay, were you born in 1994?
Sir.
Last four digits of social security number 4231.
Yes, sir.
We're here today on 23 CR 0041 for the purpose of arraignment. Do you have an attorney?
The last one I had was Shanna Burham.
She's the public defender for district court now.
Okay, well, I'll continue the appointment. Looks like you are eligible. You sign an affidavit. You are eligible. Make sure I sign this. It's time. You're here today for the purpose of arraignment, sir. You have a right to remain silent. Your attorney is here with me. Just say something to activate the camera.
Hello, can you see me?
I can't see you. I can hear you though.
Okay.
The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance. First degree heroin, possession of a firearm by a convicted felon, driving on suspended operator's license, and speeding. You understand those charges, sir?
Yes, sir.
So you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll schedule this for a conference Negotiation conference on July 12th, the next court appearance on the 27th.
Your Honor, is his bond currently set at 10,000 cash or property?
Yes.
That's what, okay. I just wanted to make sure I had it correct.
Is he a Kentucky resident? What was it? 50, it's 50,000.
Oh, is it 50,000 full cash or?
Yes,
We request a bond.
50,000 full cash.
Yeah, before it's lowered.
It won't be lower. It's 50,000 cash now.
Okay.
Okay, thank you very much, Wesley McGaw. Wesley McGaw. Are you Wesley McGaw?
Yes, sir.
This is 22 CR 00102. Were you born in 1970?
Yes, sir.
Last four digits of social security number 8985.
Yes, sir.
Okay, we're here on a probation revocation. What does the Commonwealth have to say?
Yes, I need to call Mr. Morrow and just get you on. He's on the scene.
Okay, Mr. Morrow, will you raise your right hand? Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Mr. Stockton, will you move to the left, counsel, so Mr. Stockton?
Mr. Morrow, have you been supervising Mr. McGaw?
I dealt with him for a short time, covering a vacant caseload.
Okay, when did you start supervising?
Seen him just a couple of months while he had this violation that he's on the docket for.
Okay.
That would have been from March to May.
Okay, and during that time, has he had any violations as regards his probation?
He has the current violations and he had violations at intake in March.
Okay, could you tell us what the violation at intake was? Then we'll proceed to the current violation.
The violations at intake were use controlled substance meth, use controlled substance marijuana. He admitted to both of those.
Okay, and as a result of those admissions, what was recommended?
He was referred to meet with SSC. Upon that completion, he was referred to enter and complete IOP.
Okay, did he complete SAP IOP?
No, he was referred in March. I done a follow-up in April. He had not started IOP. He was directed to contact IOP within 24 hours. And then May, I don't believe he had made contact with them or hadn't got it started yet.
Okay, and then what's the current violation that led to the incarceration and the motion?
So in May 25th, Mr. McGaw was advised of a drug screen. His drug screen was on-site positive for meth. He denied use. Additionally, the urine color was of neon green, which normally indicates dilution of some kind, usually by a cleanser. Mr. McGaw was asked about this and he admitted that he had took a cleanser when we called him in for the drug test. He later backtracked that and said that he took a cleanser once a month. I reminded him of his initial statement. The second violation, the meth did come back confirmed from the lab with a level of 2,136.5.
Which is a high level from my memory.
The highest is 12,500 and the lowest, the cutoff is 50.
Okay. Okay, I have no other questions, Your Honor.
Would you like to inquire?
Yes, Your Honor. Officer Morrow, did you speak to Mr. McGaw about any insurance issues that he was having?
It is noted that initially he had some insurance issues. That's why he was given the 24 hours to contact them on March 29th is when that was discovered.
So that was part of the delay in the SAP IOP, is that correct?
It is. It's also not a violation that's on the docket today. I didn't give him that violation for failing to enter and complete IOP.
And he did speak to you about the cleanser that he had used?
Yes.
Okay.
His statement for using it was that he was around people smoking meth, so that's why he took it.
And did he talk to you about being nervous?
Yeah, I mean, everybody's nervous here.
I understand. Nothing further, Your Honor.
Yeah, I'm gonna revoke the probation.
Your Honor, we would ask the court to consider in lieu of revocation, sending him to a long-term
No,
treatment
I'm gonna
program.
tell you what, I'm revoking it, and the reason I'm revoking it is because he tried to alter a drug test and he lied. And you know, you can lock a thief out, but he's proven to me he's a liar, and you can't lock a liar out. So on these two, so he's going to jail, and hope he learns his lesson when he goes. Okay, Thomas O'Donnell. Hello.
Well, Judge.
Commonwealth versus Thomas O'Donnell. Mr. O'Donnell, were you born in 1961?
Yes, sir.
Last four digits, Social Security 6773.
That's correct.
We're here on 22 CR 00103. There's a pretrial conference, a motion for bill of particulars, and a motion for funds, which is not an ex parte motion. Okay.
Judge, if we may first address the motion for a specific bill of particulars.
Yes.
This is specifically as to the aggravating circumstance that was noticed by the Commonwealth. Frankly, the Commonwealth's notice was pretty well written, one of the most detailed notices I've seen in a capital case. However, we're dealing with
Bask in this, it won't last long.
The thing is, we're dealing with an aggravating circumstance that I would say is fairly unusual, colloquially known as the murder for hire aggravating circumstance. And that
Colloquially known as that, I mean, we only call that Berksville. Is that what you're saying? Where are you from?
from Houston, Texas.
Yeah, what do y'all call it out there? You call it not guilty, I know.
I think Texas does actually statutorily refer to it as the murder for hire.
Yeah.
Mhm. So the aggravating circumstance encompasses different theories of guilt. And specifically, I'm talking about.
What do you want me to do as far as bill of particulars concerned?
Judge, we're requesting the court to sign the tendered order instructing the Commonwealth to provide more detail as to the specific theory of guilt that they're pursuing when it comes to the aggravating circumstance and the evidence that they're intending to offer in support of that theory. And KRS 532.0251A specifically requires the Commonwealth in a death penalty case to provide notice as to the evidence and aggravation that they're intending to use at trial. And the aggravating circumstance, whether they're alleging that the offense was committed for the purpose of receiving money or for any other thing of monetary value or for other profit, whatever other profit is, just narrowing that down for us in terms of how we need to prepare our defense in terms of that aggravating circumstance.
Your Honor, I think I've laid out a pretty good basis on the aggravating circumstances. I don't care to modify it and supplement a little bit. I would object to the order being just 30 days to respond to the motion for bill of particulars because the unindicted co-conspirator in the Commonwealth's opinion committed suicide. We think there's a TBI report that was furnished to the district attorney in Cookeville, Tennessee, that's not been released yet. I anticipate it being released pretty soon. In fact, I've got a call into the district attorney in Cookeville. So I would ask at least 60 to 90 days to respond because I want to be able to digest that TBI investigation before I supplement any discovery.
And Judge, the defense is fine with 90 days.
Okay. Well, I'd say, well, I'll hold this in abeyance and let's redocket it for how about August? Let's redocket it for August the 24th. I'll receive an agreed order anytime before then, and if you can't reach an agreement on the level of specificity he does on this bill of particulars, then we'll address it again on that day, okay?
Understood, Judge.
Okay, now what's the next thing you got?
Your Honor, the next thing we have, last time we were here, we discussed the defendant's truck that was in
Yeah,
California.
I've thought about the truck and I've consulted with judges around and administrative offices of courts and various people, the sheriff's department here. And you got a motion that has a carrier that's willing to bring the truck here
That's correct. Your Honor.
for $1,500. I'll give y'all some compliment here. That's the most reasonable motion I've ever had from a public agency to have any kind of ex parte or anything done. But I'm still worried about the chain of custody on that thing. Could you address that? With the sheriff's department, did you ever ask the sheriff, would he be interested in sending somebody out there for $1,500?
I spoke to him and I can tell you he would be willing to do $1,500.
Yeah.
Your Honor, we don't have anyone in mind that could go and travel there and come back with the truck without, additional funding being required from somewhere. Also,
Well, why don't you, do you have any testing you want done that you can do out there?
we don't know exactly what we want to do until we physically see it. So we would have to fly out there and look at it and then.
What is the Commonwealth willing to agree to as far as
Well, I
transportation?
thought about this, and I think that since the funding for the truck is so reasonable to get it towed, I think probably there should be probably that much in additional funding for some deputy or somebody or constable to go out there with the truck and bring it back. I thought Danny Arnett does a lot of traveling in Monroe County. There's different people I think that would be available if they would do it for another $1,500. I think that would be $3,000 that would be well spent by the Commonwealth of Kentucky.
What about Trooper Burton that did the initial investigation? Would he, I mean, that would maintain chain of custody strongly if he was the investigating officer, and he's,
Availability. I never know if he's working a murder case here or there or what, you know what I'm saying?
because I think
Well, in
he
the
was,
first place, we don't even know whether this carrier will allow anybody to ride back with them or not. I mean, they probably have insurance problems. They have somebody else in the cab with them, I think,
Yeah, I don't know the answer, Your Honor. I'd have
We
to
all
follow
work
up
out the
with them.
details on that. I'll sign it. If y'all can reach an agreed order, get a hold of the carrier. See if the carrier will let an officer just ride with them. I mean, it's probably not gonna be a 2-day trip, get back. They're probably gonna put them on a big van and have a bunch of them here and go in here and there and
And the
everywhere.
officer may just need to fly out there and meet them.
Yeah, but what I'm saying, I'm saying they're gonna put it on a carrier that's got other vehicles of various sorts that'll be transferred. I doubt if they'll have one trailer to bring it back here for $1,500. That doesn't sound exactly right to me.
That's right, Your Honor. My understanding, we could ask for a private enclosed trailer, but it doubles the cost. So they would be towing it back, but they would have other stops to pick up other vehicles to bring it back here. And I don't know, Mr. Stockton, if you would be willing to stipulate to the chain of custody as far as bringing it back from the carrier. That would, kind of circumvent the issue.
Yeah,
Okay.
I think they can work that out with you and get some kind of, statement that nobody will know when it's put on, nobody will know where it's coming off or anything like that. That would make it highly unlikely that anybody would alter it.
Inside the vehicle.
Okay.
Okay, okay. And what was the other thing?
That was
The other
it.
thing's a pre-trial conference. When will we get ready to set this for a trial?
Well, I'll make it with PBI file. Open so I can review it and furnish it in discovery.
and I
And I
think.
don't know about dispensing.
I think there's still some outstanding discovery too. In addition to that, I think ballistics are still pending, and some additional testing that hasn't been done on the.
I think it's been done, but we've not gotten a test
Yes.
from the FBI. So
That's
yeah,
Okay, well, I will set this case for review then on August 24th. If there's no need to be here on August the 24th, and not, if that forensic evidence comes, I'm ready to set a trial date. We don't have to wait 2 years to try these things or anything. Y'all get the level of comfort you need. say you're ready to go to trial, you can get a quick press, speedy trial for this gentleman. 31st, it's 31st. Did I give any, August
Uh-huh.
31st? Did I give anybody else that date?
We've had a couple of people, Your Honor.
We'll go back and re-notify them on August 31st, okay?
Thank you. Your Honor.
Y'all have anything else? You have the other case you still need to hear, right?
Yes, Your Honor.
Okay,
We'll wait
we'll
till
get
the
to
end
that
of
as soon as we can.
Thank
Thank you, Mr. O'Donnell.
Thank you.
Yeah, Raymond Oliver. Commonwealth versus Raymond Oliver. Commonwealth versus Raymond Oliver, 22 CR 00108. Are you Raymond Oliver?
Yes, sir.
You're here for a pretrial conference in 22 CR 00108. Were you born in 1969?
Yes, sir.
Last four digits, Social Security 1975.
Yes, sir.
Okay. What does the Commonwealth have in Raymond Oliver's case?
I think Ms. Costello wanted a little additional time on that.
Yes, in this case, Your Honor, Mr. Stockton and I have been actively negotiating it, but
You
we
want
are,
a negotiation date for the 12th and next court appearance on the,
I was gonna ask
27th.
for August, Your Honor, because we have outstanding DNA and phone dumps.
That's correct.
Mhm.
okay, what is the negotiation day in August?
We don't.
Said it yet.
Next court date's August 31st.
You did the 18th tonight.
What day of the week is that?
It's Friday.
Yes.
Friday, 18th, August 18th, 1 o'clock.
Sheriff? On transportation, of that vehicle are up to $3,000 now. You interested?
Yeah, quick there and make that climb.
Do what?
I don't.
Not interested. Not interested at 3,000. Thank you, Mr. Oliver. They have some additional testing and things that your attorney wants to have done to get the information. They've scheduled for August 18th, the negotiation day, and August the 31st. Maybe get it wound up then, okay? Thank you. Sarah Page.
Hello.
No, Sarah Page. You're here today for the purpose of arraignment, says. This is 22 CR 0019. You born in 1969.
Yes, sir.
Last four digits, social security number 36110. You're here for purpose of arraignment. The Office of Public Advocacy represents you in district court, I believe.
I believe so, Your Honor. Or no, she just shook her head. No, maybe not.
I don't guess I understand the words. I don't know. I was told I need to ask for a public defender.
You said what?
I need a public defender.
Yeah.
Okay.
Well, I'm going to go ahead and appoint one and reserve the right, whether she has to make a contribution. We put that in there. I'll sign it. You have a right to remain silent. I'm going ahead and appoint the public defender. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree, tampering with physical evidence, possession of drug paraphernalia, and criminal littering. Mr. Baylor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
It will schedule for July the 12th for negotiation day and July the 27th. Now, Ms. Page, your fiance or boyfriend earlier said that y'all previously made a bond in district court here.
Yes. Yes.
Okay, do you acknowledge receipt of that away formal reading arraignment, enter plea not guilty, reserved not pre-trial motion?
Yes, Your Honor.
Did you come up and turn yourself in, Mr. Page, in district court, or were you remember?
I did originally, yes.
How did we get Miss Page back in jail? Did y'all have to send down there for Miss Page?
They did come and get me. I don't know any other way to.
Down in Salina, they came and got you where?
They came to my house and told me that I needed.
Salina?
I've got a computer program where I can find people and we'll go to the sheriff's office down and they pick them. That's how we found it. So we didn't.
Yeah, she was ROR'd from the district court and they picked her up down there.
Yeah, I had to run it through the clear program. I got an address for them.
So they arrested her on an out-of-state warrant. That's what they
That's
did.
correct.
didn't
You
have
got
to-
somebody in CIC, then you can get them arrested on out of state one.
Was she an NCIC?
I don't know that she was.
I don't think she had it.
But I think maybe they honored it without her being put in. But I know I've got her. Yeah, we wrote the letter June the 1st, 23 to Clay County Sheriff's Department, and she was picked up soon thereafter.
Okay, well, I want you to waive extradition back to Kentucky. I'm gonna set a small bond for you. I'm gonna set a $5,000 bond. You can have somebody come up, post $500, 10%, okay?
I have no income. I'm on disability, Social Security. And
Well, you got $100,000.
I missed an appointment.
$1,000 house, don't you?
I do have a house, but I don't have anybody that can
Well, that's
do anything
what
with it.
about your boyfriend that was advocating you a while ago? Can he help you post a bond? He's got a cash bond up.
I mean, I paid his last time. I don't know how to do these.
What's she charged with, Mr. Shaw?
Yes, it's possession and tampering and drug crippling.
Okay, well, what I'm gonna do, I'll do a $2,500 bond, so you have somebody bring $250 up. I'll give you a break on that. And then do you waive extradition? We're gonna send a waiver of extradition. She'll come back without us having to go through NCIC. Is that correct?
That just means you'll agree to come back to court without them having to come and get you.
Yeah, as long as someone lets me know I need to be there, I'll be there.
Yes, we're giving you court dates today.
Okay, your court date is, you have to be up here for negotiation on July 12th and back in court on July 27th, and the waiver of extradition will be a $2,500, 10% bond, okay?
Good. She does have a Clark County, Tennessee detainer as well.
She has what?
He said Clark County.
Clay County, Tennessee, I'm sorry.
Clay County, Tennessee detainer.
Yes.
There's nothing I can do about that. So I'll just set the bond here. Okay, thank you. Parker Purdue. Parker Purdue. You need to tell her she needs. As far as somebody down there to take care of whatever that detainer is.
Yes.
Commonwealth versus Parker Purdue. 22, do what? Where is Mr. Garrett? Do what? 22 CR 0061. Get Mr. Garrett. Mr. Garrett here. There's Mr. Garrett. Are you Parker Purdue?
Yes, sir.
You were born in 1979.
Yes, sir.
Last 4 digits, social security number 3571. We're here on a pretrial conference. What does the Commonwealth have to say?
There's a felony plea, Your Honor.
Mr. Purdue. A motion has been entered. It says you wish to do a felony plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes, sir.
State your full name, please.
Parker Eugene Purdue.
Are you the same person named in indictment number 22CR0061?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed the charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Do you feel like you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial, but jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt your guilty charge against you. Understand that you enter a plea today. You give up all those charges. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will order a pre-sentence investigation report on my probation parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation? Move to the left of the Ms. Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to criminal mischief, first degree, and persistent felony offender, second degree, the defendant shall receive a sentence of 10 years. Upon a plea of guilty to assault, third degree, and persistent felony offender, second degree, the defendant shall receive a sentence of 10 years. Upon a plea of guilty of burglary, second degree, and persistent felony offender, second degree, the defendant shall receive a sentence of 12 1/2 years. These three sentences shall run concurrently for a total of 12 1/2 years. The defendant shall receive credit for time served. That would be 429 days as of today. The defendant shall remain incarcerated until August 15, 2023. At that time, he'll be released to Owensboro Regional Recovery for mental health and substance abuse treatment. As on August the 15th of 2023, he would have had 477 days of jail credit upon his release. If the defendant leaves the facility without being properly discharged or against advice, he shall immediately report to probation and parole wherever he shall be and taken in custody. Upon proper completion of rehab, the remainder of the 12 1/2 years shall be probated for 5 years. The probation is to be supervised. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained.
Is that what you agreed to, Mr. Purdue?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment or the indictment as amended?
Both.
Do what?
Both. Yes. Yes.
Knowing your constitutional rights, have explained, is it still your desire to give up these rights, enter a guilty plea, and allow the court to fix your punishment within the range of sentence permitted by law? Knowing your constitutional rights, as I've explained them to you, is it still your desire to give those rights up and enter a guilty plea today? Is that right?
Yes, sir.
Okay. You agree to allow the court to fix your punishment on these charges?
Yes, sir.
You understand that by entering a guilty plea, any future convictions of felonies could be enhanced as far as your range of penalty. You understand that if you get any felonies in the future?
Yes, sir.
Okay, do you have the document?
I do, Your Honor.
Is that your client's signature on there?
It is, Your Honor.
Okay, I'll accept the agreement, order pre-sentence investigation report to be done by probation and parole. And schedule sentencing for the 27th of July. Thank you very much. Hannah Scott. Commonwealth versus Hannah Scott. Are you Hannah Scott?
Yes.
This is 21 CR 00140. Were you born in 1994?
Yes.
Last four digits, social security number 1267.
Yes.
We are on a probation, pretrial diversion revocation. What does the Commonwealth have to say?
I'll just let Mr. Garner explain this. It's all right.
Okay, Mr. Garner, come around here. You raise your right hand, you swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Please proceed.
Mr. Garner, you've been supervising Ms. Scott,
I have.
and what type of difficulties did she had with?
Well, I got notified that she had a new misdemeanor arrest where she was charged with public intoxication and disorderly conduct. We drug tested her and she tested positive for methamphetamine. I gave her a violation for leaving the area of supervision. Because she was picked up in Glasgow or Warren County at the time. And at the jail, they said that she was talking to them normally. And then I guess whatever medication that she was on had worn off and she started talking very erratically about things that don't exist.
Having mental health issues.
Yes.
in Jail. That's just, she was basically.
I need to take a break just a second. I'll be right back. Excuse me, I'll be right back.
I'm fine with whatever, I mean, as long as she's got stuff in there. Whatever's going on, even if she takes her medication properly, then that's gonna make her put them right back.
Oh, yeah. She won't last that long if she keeps taking it. Hell, I don't know. Give me 2 chunks like this. Still, it's not good. Solution.
And where's your shot?
See, what you're saying? Give her some playing the song. And we sample across in several places. Where we was. And a pumpkin on one head. Right. And he only carried the thing between 2 presidents. I think he just carried it. He says, take 2 days. They couldn't do the presidential. I know it's mine. Carried it outside. Just take you. Just take you. Stay all right every day. You had it. You had it. Take a special spot. You have to break this spot. National one way. So 3. There's no money in there.
Let's go back on the record, please. You can continue.
Officer Garner, what would your recommendation be as far as Ms. Scott is concerned, given her mental health issues and substance abuse issues?
If the court doesn't elect to revoke her, a dual diagnosis, long-term rehab would be suitable.
And Your Honor, I have no further questions for Officer Garner. I have spoken to Ms. Scott and she is now on her medication. The jail is giving it to her. And with a clear head, she very much wants to go to the type of treatment like that, that can treat both of her issues and allow her to continue to take her mental health
Y'all have a
medication.
place that is suggested?
Your Honor, there are 2 facilities that I have recently worked with that have, are doing well with my dual diagnosis clients. We would refer her to our ASW, and I've talked to Mr. Stockton. She would remain in custody until that treatment bed is found. The one that I'm thinking of, Your Honor, they actually transport. So they would come to the jail and pick her up and take her there. So,
Well, I'll wait for an agreed order.
okay.
And if the agreed order, taking this in abeyance and then letting her, sending her to the, we're gonna get you somewhere to try to get your medications straightened out, young lady, okay? Thank you.
Okay.
Jason Cheryl. Commonwealth versus Jason Cheryl.
Yes, sir.
Are you Jason Cheryl?
Yes, sir.
Mr. Cheryl, were you born in 1976?
Yes, sir.
4 digits, your social security number 8694.
Yes, sir.
Today on 21 CR 0041 for arraignment. Do you have an attorney?
No, sir.
Yes, I see your affidavit here.
That's another type of.
I'm going to appoint you a public advocate and I'm going to assess a $500 fee to be paid within 60 days. Or would you prefer getting your own attorney? Which one would you rather do?
No, that'd be fine. I need to, that'll work.
Okay. You're borderline as far as your income is concerned, but I see it's a seasonal income because you're a roofer, and I know with the winter months, you're not going to do too much during those months. Your attorney is here. You have a right to remain silent. The grand jury has returned an indictment charging you with trafficking and controlled substance in the first degree of Class C felony. Counselor, you acknowledge the identity of your client received the indictment away from Oregon and an error plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
You've entered a plea of not guilty, reserving all pretrial motions for Mr. Sherrill.
Yes, Your Honor.
What's his bond now? How much? Who's saying that? Somebody out in the crowd there. Why is it that high? Why is it 25,000? Is it surety? There's some reason it's higher than normal. Why is that? That's what I just said. Why is he modified? Where were they?
Either.
Yeah, he has some FTAs.
I didn't know I was supposed to be in court. I was in the sun.
It's okay, Mr. Sherrill. They're looking into your bond right now.
Sorry.
Do you know anything about that?
Your Honor, during that time, we still would have been dealing with the COVID issues with a remote court. So I can't say if that would have factored in or not.
In 22?
I thought she said 21, Your Honor.
I will show up for court. I'll be there.
It looks like the FTA days was. Oh, I thought she said June of 21.
It says, Cumberland FDA also 6/9/21. So apparently they're the same.
Okay, so I only heard the June one, Your Honor. I don't.
What are the other reasons? What was that? It's some kind of violent offense in 214. Well, I'm gonna leave his bond the way it is, and you can negotiate for Commonwealth.
It was, oh, that was.
Wait, don't say anything. It could be used against you. Your attorney's gonna negotiate your bond with the Commonwealth, and we'll get back with you. That way you can talk to her privately, okay? Yeah, you got a pretty extensive record, so you don't need to negotiate that. Thank you, Mr. Cheryl. We'll see you here on the 12th and the 27th of July. Jacob Smith. Jacob Smith. Are you Jacob Smith?
Yes, sir.
Okay, you're here on 23 CR 0032. Were you born in 1987?
Yes, sir.
Last four digits of social security number 4054.
Yeah.
We're here for a pretrial conference on Mr. Smith. What do you have, counselor?
Your Honor, we are still waiting on the lab report in this case.
When do you think, how far out are you on this, Mr. Stockton?
Let's see. I don't see another. We may be 30 to 60 days out. It's a possession case. What's the bond?
His bond is currently set at 25,000 cash. I think, Your Honor, I don't know why it was.
Take a look at him.
He does, I can tell the court, he does have a pending case in Casey County, but it's from several years ago. I think 20, well, I shouldn't say several, 21, so 2 years ago. And that may be the reason, because he had a new charge while on bond, Your Honor.
FTA in Clinton County.
When did that occur? May have been in custody, but I can't swear to it. Know anything about that one?
He's got charges pending in the case. That where you said Casey?
Yes, Your Honor.
You can negotiate that with the Commonwealth. And we'll check on the lab report. We'll skip.
Do you have the right Jacob Smith? Because there are two. He's Jacob A. Smith.
I can't hear you.
He's Jacob A. Smith. There's another Jacob Smith, Your Honor, that currently has cases. So that may be the confusion, but he just had court on Monday. So he believe me, I wouldn't admit to pending case that we didn't have.
I'm not understanding what you're saying here. There's a different Jacob Smith. Is that what you're
Yes,
saying?
there are two Jacob Smiths that are both currently in the Adair County Jail, Your
Were
Honor.
both of them born in 1987?
Believe this Jacob Smith has been was born in 78. Is that correct? Jacob, what's your date of birth?
1987.
Okay, well,
And they've got it on my paper over here on this indictment paper. They got it 1978.
yeah.
I've got my stuff mixed up here.
Well, you done lost 10 years. You ain't been in jail no time.
Yeah.
You'd rather be in jail another year than lose 10 years of your life, hadn't you?
Well,
Well, yeah, we'll let your attorney get up with the Commonwealth attorney and negotiate your bond, okay?
3 days.
What is it?
Probably another 30 days. We'll have
Okay, well, let's schedule him for the 12th and the 27th. Does he have any other? Jacob, do you have any charges pending anywhere else?
The only ones I got's in Casey County, and I'm out on bond on it.
Yeah.
He's got a Clayton County holder, $100 bond.
Yeah.
You got something in Cleveland County?
I got a figure to appear in Clayton County.
He was incarcerated, I believe, on that, the newest one, you're going to
In Casey County or Clinton County?
Clinton County.
Well, let's leave his bond the way it is. He seems to be on a one-person crime spree here, Jacob. We'll try to get negotiated here. Be here on the 12th of July for a conference and the 27th, and your attorney's gonna talk to Commonwealth Attorney about the bond when they put all these cases together.
All righty.
Okay. Let me have just a second run through the rest of this document. Tell them they need to take a seat. Be all right. I'll be right with it. Commonwealth versus Keith Smith. Keith Smith. I just got about 6 or 7, Mr. Judge.
12 o'clock, I guess the doctor.
Yeah. Keith Smith. Are you Keith Smith?
Yes.
Born in 1963.
Yes.
Last 4 digits, social security number 8253.
Yes.
This is 23 CR 0024. Says a pretrial conference and motion to reduce bond. Is that right?
I've only recently got in the case and I did file a motion regarding bond, Your Honor.
What is his bond now?
I believe it's 15,000 cash, Your Honor. And
wait a second.
If I may make a couple of points on behalf of Mr. Smith, Your Honor, I'd like to.
$15,000 cash.
Okay, it's $15,000 cash. Why is that?
Is another 3 low rate. Looks like he had a failure on July 13th, 2022.
I can't hear what she's saying.
He had a FTA. Where was that?
That's here, sir.
July of 22. And what else? What other problems does he have?
The other thing I think was because he was, it was a Class C felony.
Class C felony.
The charge is convicted felon possession.
That's one from 33 years ago.
That's for your motion.
That's what I've been told. Nobody has any records that far back. I've been told that the prior was 33 years ago. And the other point I wanted to make is he works for Junior Smith mowing yards. And
You're right, it's a burglary from 1990.
1990. Okay. And as soon as it quits raining, I'm sure Mr. Smith's got plenty of work for Mr. Smith. So if we could get a reasonable bond set, I think that'd be appropriate. Of course, that's in the eye of the beholder, but he can make some sort of bond, but he can't make a very big one.
I'll do it. 15,000, 10%.
Okay, that's fair.
And then he's under curfew.
Okay.
Work, church, doctor.
Keith, do you understand that?
Yes.
Okay, call me when you get out. I'll talk to you people, okay? We could just pass it on.
Be here to the 12th and the 27th.
Oh, I'm free to go home.
No, you got a $15,000 bond, but I'm gonna let you do 10%. So somebody put $1,500 up, you can get out.
Okay.
Okay, and then you're restricted to work, church, home, or the doctor. Okay.
Okay.
Okay, thank you. You be here the 12th and the 27th. William Spears. Commonwealth versus William Spears, 22 CR 87. Are you William Spears?
Yes, sir.
Born in 1974. Were you born in 1974?
Yes, sir.
Last four digits of social security, 1612.
Yes, sir.
For a probation revocation here, and what does the Commonwealth have to say?
That's a motion to revoke, Your Honor. He got a new felony.
Okay, you have to get over here where he can hear you. Thank you.
It's a motion to revoke probation. He has a 3-year sentence on possession. And he got a new charge in Cumberland County, trafficking in a controlled substance, first degree, over 2 grams of methamphetamine. And I don't know, did that case go to grand jury today?
What's your name?
William Spears. It's either going either today or next month.
We had the preliminary hearing yesterday.
So that's it. Be next month.
Your Honor, and given that I had talked to Mr. Stockton about setting this over until that charge was up, so we could talk about both of them together.
Okay. The conference, we'll have a negotiation conference on July 12th. And on the 27th, it would be your next court appearance. And there are new charges here, so what do you have, what's the bond set at now?
Thought he was being held on a no bond because of the probation violation, Your Honor.
Okay, keep him on that, okay? Wendell when your attorney will be called, you said Wendell Stearns. Wendell Stearns. Commonwealth versus Wendell Stearns, 23 CR 0033. Are you Wendell Stearns?
Sir.
Were you born in 1994?
Yes, sir.
Last four digits, social security number 0777.
Sir.
You're on Pre-trial conference. What do we have?
Your Honor, in this case, Mr. Stockton and I met, and he would like to do a drug court referral that's already been signed, but prior to making an offer, wanted to see the result of the.
Schedule it for 12/20 for negotiation on the 12th and next court date on the 27th.
Yes, sure. And
We're gonna take a look at a drug court referral on Mr. Stearns, and if you get a drug court referral, some of this stuff might go away if you're accepted. You understand what I'm saying? So just be patient there, and your attorney will be in contact with you.
and Your Honor, would the court consider looking at his bond?
No. No, we'll move through with this thing here and protect his health and stuff by keeping him there until we get him somewhere. Peyton Sullivan. Peyton Sullivan. Commonwealth versus Peyton Sullivan, 21 CR 0063, here for arraignment. Mr. Sullivan, do you have an attorney?
No, I don't have one.
Okay, can you afford one?
No.
You have a job?
I do have a job, yes, but, I mean, I have it as soon as I get out of here, I still have my job, yes.
Have he filled out a form? Well, I'll put him one for just the purpose of arraignment. Okay, you have the right to remain silent, Mr. Sullivan. How much, Mr. Sullivan, bond? Okay. The grand jury of Cumberland County has returned an indictment, 21 CR 0063, charging you with possession of controlled substance, obstructed windshield, reckless driving, and speeding. You understand those charges, sir?
Yeah.
Counselor, do you acknowledge the identity of your client, receipt indictment, waive formal reading and arraignment, enter plea of not guilty?
Yes, Your Honor.
We will schedule the 12th and 27th, $25,000 surety bond. Is that right? He's a Tennessee resident.
Your Honor,
Yeah.
would the court consider a smaller cash bond, of 500 cash?
What other kind of gradations does he have here besides this charge here? Do you have any FTAs or other criminal history?
I mean, I ain't got no FTA.
Okay, he'll have to be interviewed for a bond reduction. They're gonna be, the pretrial people gonna be getting in contact with you Mr. Sullivan to see if we can reduce your bond somewhat. But you're an out-of-state citizen. Will you waive your right as far as extradition? In other words, you'll sign a paper that says you'll come back without a governor's warrant. We let you out. You
Yes.
understand?
Oh,
Okay.
yes, yes. It's something else.
Okay.
Until she turned himself down.
Yeah, you turned yourself in, so we'll let you sign a waiver of extradition. You made a statement in open court that you'll do that, and we'll see what we can do about lowering your bond after they take a look at you. So there'll be that. Yeah, yeah.
Because he's Tennessee. He doesn't have to.
Well, you can interview him anyway.
We did it.
Well, what's his background? He has no record in Kentucky or anything.
I can make a property bond if that will be allowed.
You have property in Kentucky?
My grandpa has a friend that has property up here that he said he would sign my bond and everything.
Okay, well, what I'm gonna do is I'll do you a $5,000 property bond. And then, and you sign a waiver of extradition. You stay out of Kentucky and except for your court dates, okay?
Yes, yes.
Okay.
Mr. Sullivan, can you give a phone number, please?
No, I use my dad's phone number because my phone is.
That's fine.
931-290-8135.
Thank you so much. And they have my cards at the jail. Make sure you get one before you leave, okay? So you have all of my contact information.
All right, thank you.
Okay. Tell them to come up here to Cumberland County Courthouse and they can make the bond. Who are we at now? Clay, Sean, and Thomas. We just got 3 more. Tell Granger will be with us.
Yeah.
Shaquan Thomas. Are you Shaquan? Are you Quay Sean Thomas?
Yes, sir. Quayshawn Thomas.
Okay, you're here on 23 CR 0042. Were you born in 1997?
Yes, sir.
The last 4 digits, social security number 3952.
Yes, sir.
You have an attorney?
No, sir.
Were you in district court?
Yes, sir. They sent it to the grand jury.
Yeah.
Yes, sir. Yes, sir.
In district court, did you have an attorney that was a public defender, your attorney in district court?
Yes, sir.
Okay, I'll continue that appointment. Your attorney is here now. You have a right to remain silent. Looks like I have your affidavit. You are entitled to a public defender. Go ahead and fill this in. Where's? Okay. The grand jury of Cumberland County has charged you with possession of firearm by a convicted felon. And being a persistent felony offender. Do you understand those charges?
Yes, sir.
Okay. You acknowledge the identity of your client, receipt of that, will waive formal reading and arraignment, enter plea and not guilty, reserving all pretrial motion.
Yes, Your Honor.
Okay. The 12th and 27th for your next court date.
Your Honor, what is his bond set at?
What's the bond? Yeah.
The indictment said 10,000 cash or property. I just wanted to make sure.
That's what it is. Your attorney will be up to see you, explain things to you very soon. Next court dates at 27th. He'll be here on July 12th and July 27th. Charles Thurman.
We was at the same.
We got 2 more people after this, and your doctor. Okay.
Yeah.
Is your doctor okay?
Yeah, we can get her lined up. She has to wait for it.
Okay.
She's on the same that now.
Commonwealth versus. What's your doctor's name?
I think it's 3 more. She just gets skipped up.
What's your doctor's name here?
Martina Burns. She's on the end.
I think she's popped up now.
Martina Turns, is that correct?
Yes, that's right.
Dr. Turns, we'll be with you in about 5 minutes, okay?
Okay, thank you.
Turn your camera off till then, we'll be good. Commonwealth versus Charles Thurman. Are you Charles Thurman?
Sir.
Okay, you're here on 23 CR 008, 9, 11, and 12. Were you born in 1987? You born in 1987, Mr. Thurman?
Sir.
Last 4 digits, social security number 6117. Is that correct?
Yeah.
Okay. We're here on a pretrial conference.
Your Honor, there was an order entered to have him evaluated by KCPC in district court. We've had to modify that order. On June the 8th, we got the request from KCPC that's tendered discovery so they could do the outpatient evaluation. So I expect it to be done anytime.
Okay, Mr. Thurman, the people from KCPC will come down for an evaluation and your lawyer will be in contact to fully explain to you what's going on for sure, okay?
Okay, thank you.
Yeah, thank you. Raven Willis for sentencing. Commonwealth versus Raven Willis, 21 CR 0061. Are you Raven Willis?
Yes, sir.
Born in 1991. You born in 1991.
Yes, sir.
Last 4 digits of social security number 8224.
Yes, sir.
Here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done for
Yeah.
parole?
Yes, sir.
Substantially correct.
Yes, sir.
Counselor, is there any reason Slade should not be sentenced today?
Yes, Your Honor, we were here last month on a pretrial diversion violation. The court did at that time revoke her diversion. Mr. Stockton and I had talked and would think that a drug court referral would very much help Miss Willis with her issues, and she is very willing for that program, Your Honor.
Do you want me to rescind the revocation or what do you want?
Well, I think I got confused, Your Honor. I thought she was on for a motion to revoke. If she's going to be sentenced, I'd be one to put her in drug court on the shot.
Come on up here so she can hear you.
I think I may have gotten confused about the status of the case file. I would be agreeable to a drug court assessment and letting her out on a shock motion. But after she's already been revoked, I think she needs to be sentenced since she was in there. That's my opinion.
Yeah, I'm gonna send order a pre-sentence investigation report to be done by probation and parole.
Yeah, we've done that, Your Honor. It is.
Okay, oh yeah. You didn't,
Yeah, I got confused when I was telling Miss Costello. I thought she was on for revocation, but she'd already been revoked.
Yeah, she was revoked last month.
I got the pre-sentence investigation.
Yeah, so once she's sentenced, I'll look favorably on a shock motion for drug court. We can
Okay.
Okay.
Yeah, I sent you to 3 years. And then what the Commonwealth has said is they're gonna consider shock probation and putting you in drug court as soon as you're eligible, okay?
Yes, sir.
Okay, okay, thank you
So
very
you
much.
were okay with the referral going ahead and being, okay.
You submit one, submit a great order.
Your lawyer will be able to explain the timetable to you, Miss Willis, okay, and get the information, and I'll do the drug court referral. James Wilson. James Wilson. Commonwealth versus James Wilson, 23 CR 0043. Are you James Wilson?
Yes, sir.
Do you have an attorney?
No, sir.
You have one in district court?
Yeah.
Was at the public defender's office?
Yes, sir.
I'll continue that. Looks like you're eligible. Were you born in 1996?
Yes, sir.
Last 4 digits, social security number 1308.
Yes, sir.
Okay. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, and violations of conditions of release. Counselor, you acknowledge the identity of your client received the indictment, away formal reading and arraignment, enter plea not guilty, reserving all pretrial motion.
Yes, Your Honor.
Set this for the 12th for negotiations and 27th for the next appearance.
Your Honor,
His bond is $15,000 clerk approved surety. Isn't that correct? Is that what it says on there?
that's what I had on the indictment. I just wanted to
Okay,
make sure.
Okay, that's correct. Now, we have some to take up before we go to the testimony from the doctor.
Did we skip over Kristen Cooper?
I don't have her on my docket.
She is on the
Okay, it was oversight. She wasn't on the docket. Is she here?
She's in jail.
Okay. Kristen Cooper.
Yes, sir.
Okay. Commonwealth versus Kristen Cooper, 22 CR 0027, 22 CR 0028. What do you have, Mr. Stockton?
It's a motion to revoke probation, Your Honor. He has a three-year
Come over here so they can hear you.
possession of controlled substance.
Start all over again. Can you hear him, Ms. Cooper?
Barely.
Just speak up a little bit.
She's got a 3-year sentence for possession of a controlled substance, first degree. And her problem is she's had multiple failed drug tests, including fentanyl. She's also had the most recent drug test, June 21st, she was positive for hydrocodone, Suboxone, fentanyl. And I don't know if meth's on there or not, some kind of oxycodone looks like. And she's also, according to Mr. Garner, brought in a bottle with fake urine. So that's the violation.
You want testimony?
No, Your Honor. Ms. Cooper stipulates and admits to these violations, Your Honor. She never had a drug problem until after her mother, Robin Burns, passed away. Her drug problem started shortly thereafter. The court was gracious enough to give her pretrial diversion. However, she didn't have any type of rehab or drug court. So she's asking the court to let her be assessed for drug court. Let her remain in until that assessment comes back, and then give her that strict supervision the drug court provides. So that way she's got something to support.
Well, I think under the circumstances, it would probably be the best thing to do because she's only got a 3-year sentence on the possession. And she's using the fentanyl on more than one occasion, and she's going to end up dead if she doesn't do something. When she gets out, if she goes back to fentanyl, she's not going to last long.
Well, you know, I also find this fentanyl, I believe some people are testing for fentanyl are taking what they think is meth. It's laced with fentanyl.
Yeah.
So she might not be intentionally taking fentanyl, but it's just as dangerous.
Just as
either way.
deadly either way.
That's exactly right.
Yeah.
Okay, well, I'll let her stay there till next month. In between now and then, we'll do a drug court referral and see if we can do her some sanction time instead of revoking her.
Yes, sir.
They'll get up there and talk to you and see if you're eligible for drug court. And if you are, we'll consider the time you're in a sanction time. If the Commonwealth's doing that, okay?
Thank you.
Thank you very much. Now, what do we have left here?
Ronnie Anderson, drug court diversion. If we could do it, I'd be done.
Okay. Do we have anything else besides that?
Yeah.
Okay. Commonwealth versus Ronnie Anderson. 23 CR 0021 and 23 CR 0031. Are you Ronnie Anderson?
Yes.
Now, do we have anything else at the jail? Mr. Stockton? Okay, we still need the Dare County Jail to stay on for Mr. Humphrey's thing. This is Commonwealth, Kentucky versus Ronnie Anderson. Mr. Anderson, born in 1960, said last 4 digits, Social Security number 8591. We have a resolution, Mr. Cross, in this case.
Yes, drug court diversion, Your Honor.
Good. Diversion plea. The motion been tendered, says you wish to enter a plea today, Mr. Anderson. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you doing this freely and voluntarily?
You're doing this
Okay,
on your own?
wait a second. Wait
I
a
can't hear you.
second. Can you hear me?
No, not real good.
Give him some earphones. We'll get you some earphones. Do you have hearing aids in?
No,
Okay.
I just I always had bad hearing. So here.
Put it under your chin still there.
Hold it down, not up, hold it down. Put this down, Ronnie.
Look like a unicorn there.
There you go.
There you
How's
go.
that sound? Are you doing good
Can
now?
you hear better now?
Yeah, I hear you now.
Okay, a motion's been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0021 and 31?
Yeah.
Is your judgment impaired today in any way? Have you discussed this charge with your attorney? Are you satisfied with his advice?
Yeah.
Have you viewed all the evidence? You feel like you're fully informed about your case?
Yeah.
You have certain rights under the Kentucky United States Constitution. You do not have to plead guilty today. And I have to know you understand those rights that you're waiving. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yeah.
Now I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yeah.
Have you previously been diverted in the last 5 years?
No.
Have you had any felony convictions in the past 10 years?
No.
Are you currently on probation?
No.
You understand that if you fully complete the diversion program, the charges will be dismissed.
Yeah.
You understand that if you not fully complete the diversion program, you'll be brought back before the court. The court could schedule a sentencing hearing. You'll be a convicted felon. You understand that? What is the Commonwealth's recommendation, Ms. Gordon? Step to the left there, Mr. Anderson.
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, in case number 23 CR 21, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08, or while under the influence of alcohol or other substances, first offense, in case number 23 CR 21, defendant shall receive a fine of $200. Upon a plea of guilty to possession of a controlled substance, first degree, in case number 23 CR 31, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to endangering welfare of a minor, 1 count, the defendant shall receive a sentence of 12 months. The sentences in 23 CR 31 are to run concurrently for a total of 2.5 years. They still have it on here as 1 count.
Now there's 2. This is 1. There's 2 counts. Okay. This is 2. Okay.
There were 2 counts they dismissed.
The sentences in case 23 CR 21 and 23 CR 31 are to run consecutively for a total of 5 years. Pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall enter and complete the Cumberland County Drug Court program, shall pay fines at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant shall remain on active supervision until any and all fines are paid in full and until further request of probation and parole. And the defendant shall agree to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Sir, is that what you agreed to?
Yeah.
Are you pleading guilty because you did commit the acts charged in the indictment or as amended?
Yeah.
Okay, you're doing some of your own free will?
Yes.
Okay, now you understand that if you violate the terms of this agreement and you are revoked, that you would be a convicted felon and any future felonies could be enhanced. You understand that? You also have a DUI. Do you understand that if you get another DUI, it could be enhanced, you get another?
Yeah.
What's the total fine?
On both cases, it will be $1,040.
$1,040. You need some time to pay that.
Yeah.
I'll let you pay it at $50 a month.
Okay.
Okay, and first payment is 30 days from today. Is that your signature on the motion?
Yeah.
Okay, I'll accept it, give it to the bailiff. Need to meet with the probation parole officer.
Right over there.
That needs to be signed. We got another document needs to be signed here.
You're another DUI.
Well, yeah, we gotta sign the DUI form, right? Just do it here and we'll do it right now.
Just take it to the table there. Take it to the table. And do we have anything else going on besides this hearing now?
No.
Is there anything in the docket finished?
I didn't know where else you were.
Yeah, we had never heard anything else from Peyton Boone.
She sent a letter.
There's a letter. Who's it from the
Yeah.
doctor?
Yes, Your Honor.
What does it say?
Your Honor, it talks about her being sick. This letter is dated June 23rd, Your Honor, from where she was sick last Friday, and it continues to be. They did not give an update on when she would be able to return.
Let's see it.
She is due around the first week of August. And Ms. Brewer self-reported to me that she currently has a fever of 101, Your Honor.
She needs to go to the emergency room. Give a statement from the emergency room or any of the clinics. We got 2 clinics you can walk into without going to the emergency room. They got a clinic at the hospital and they got the Flowers Clinic. And when they got the other clinic, we got 3 clinics she can walk into. She doesn't have a doctor's excuse, but here about 4 o'clock, I'm issuing a warrant. This does not indicate she's got any problems whatsoever. It just said she was going up last week for a checkup. Okay, so you can tell her that. Okay, that concludes this docket except for the hearing. I'm gonna bring the grand jury in first. Yeah. What was- Yeah, and then with my others that I always put in there too. Church work doctor. We need to clear that area over there. Look at that, please, and bring your grand jury. Right, it seems like 30 years. Dr. Turns, we're about to come to you right now. I'm just gonna get to report the grand jury. Thank you for your patience. All rise to grand jury, please. Okay, everyone can be seated. Madam Foreperson, have y'all completed your work for the day?
We have.
If 9 or more of you voted on each one of those?
Yes.
Mr. Bailiff, will you retrieve those and bring them over here? Thank you. Okay, everything appears to be in order. I will initiate the procedure by signing this document so that either the warrants or the summons, if they're in custody, there'll be summons. If they're not in custody, there'll be warrants with a reasonable bond to assure the public safety and their appearance here in court. Now, there has been some rumor that you've requested as a grand jury to serve another 6 months. Is that correct? Or is that just?
That's
Is
false
that a
information.
is that a false information? You think we ought to investigate whoever said that for perjury?
Exactly.
Okay. Well, thank y'all very much for your service here. You perform a very important part of the process. No one can be brought before the bench here in the circuit court and charged with a felony unless a grand jury of their peers finds there to be probable cause. And I would remind you that the things that you have heard in the grand jury room should still remain confidential in nature, and you shouldn't share those with anyone. I thank you on behalf of the citizens of Cumberland County and the citizens of Commonwealth of Kentucky for doing your duty here on the grand jury. I know it's not a pleasant task to nobody ever comes in the grand jury and say, well, everything's going just fine. You know, it's always a serious issue or a problem, and y'all conducted yourselves appropriately. You may be excused, and the good news is in state court, you do not have to serve on a jury for 2 more years. Now, I can't do anything about the federal court in Bowling Green. You might be drawn out there, but in this court, you are excused, and your checks will be coming. When will the checks be there?
Probably.
It's $12.50 a day, so I figure like you almost got $70-something coming to you, but we won't be holding anything out. No Social Security, no anything like that. You have to report it on your own. All rise for the grand jury, please. Right. Thank you again. Okay, everyone can be seated. Now we will go to the Humphreys case. Commonwealth versus Lance Humphrey. I see you there, Mr. Humphrey.
Yes, sir.
This is 22 CR 0057. Your attorney is present here. If you have anything you need to ask your attorney, you can raise your hand and then we'll make her available to do that. You want to call your first witness for the competency hearing? For the
Yes,
Commonwealth?
doctor, I believe it's Martina Turns, is that right?
Yes, that's right.
Yeah. Doctor, you raise your right hand, please. You swear the testimony you're going to give is the truth and no truth and nothing but truth, so help you God.
Yes.
Okay. Mr. Stockton, you may inquire.
Okay, thank you. What's your occupation?
I'm a licensed clinical psychologist.
And when were you licensed?
2002.
And could you give us a brief description of your education and training, please?
Yes, I've been a licensed clinical psychologist for the past 21 years. I completed my doctorate in clinical psychology at Indiana State University, my internship training at the VA Medical Center in Lexington, Kentucky. I was employed as a staff psychologist at Eastern State Hospital for a couple of years, and I've spent the majority of my career in private practice, primarily doing civil forensic assessment initially, and then since October of 2014, I've been completing competency and criminal responsibility evaluations at KCPC.
Okay, thank you. Dr. Turns, has KCPC previously been ordered by the court to examine the defendant, Lance Humphrey, concerning his competency to stand trial?
Yes.
Okay, and could you briefly describe the procedures and processes used at KCPC to determine competency?
Yes, so once the individual arrives at KCPC, the evaluator will usually take a look at the documents that are generated at the time of admission to KCPC. In this particular instance, we have a history and physical examination as well as a biopsychosocial evaluation, the results from the jail in terms of what the individual was doing at the jail, and any sort of collateral information that we can get and collect during the patient's stay. So I reviewed that information and then conducted the formal competency evaluation on April 26, 2023. And that evaluation was completed in approximately 45 minutes. During the course of that evaluation, I will ask competency related questions. Typically that involves the patient's understanding of the roles of courtroom participants, what the charges are, what it means to plead guilty and not guilty, things of that nature. And then I take those responses and I compile them and put them in a report, as I did in this case, and then provide an opinion to the court regarding competency.
Okay. In this case, there was psychological testing performed on Mr. Humphrey. Is that correct?
Yes.
And could you briefly describe the types of tests and how you performed on those?
Yes, so we always will give not always, but most of the time we give an effort test that lets us know whether or not the patient is giving good effort. In this case, Mr. Humphrey completed the RAE 15 and was noted to give adequate effort on that measure, suggesting that any cognitive testing would generally be consistent with where he actually falls intellectually. His IQ testing indicated a full scale IQ score of 90, which places him within the average range. And that was consistent with his reading ability, which was a standard score of 92. And that also placed him at the 10.9 grade equivalent level, generally average in terms of the numbers. As far as attention and concentration, he did show some deficits in that area on a test we call the color trails test. And so he has a little bit of trouble paying attention to visual information. And that test tells us that if he is presented with any sort of visual stimuli, that information might need to be slowed down or broken down in order to facilitate his understanding of that information. On personality testing, there were no scores that fell within the clinically significant range, though he was noted to be somewhat defensive on testing. It did not elevate in terms of psychosis, mania, or things of that nature, which is kind of what we would want to be looking for in that particular test. And his score did not suggest the presence of those conditions.
Based on those scores and the diagnostic interview that was done, did you form any diagnostic impressions as regards Mr. Humphrey's condition?
Yes, so he received a diagnosis of unspecified psychotic disorder, which essentially means that there is the presence of psychosis, but we don't know the etiology. In other words, we don't know the origin of the psychosis. When individuals have substance use history, which is the case with Mr. Humphrey, oftentimes the substances that are used, cannabis, methamphetamine, opioids, things of that nature, those are known to cause psychotic thinking. Those are known to cause mood dysregulation, things of that nature. And in the case of Mr. Humphrey, we listed that as a rule out. In other words, he has psychosis. We don't know where it comes from, but there is a possibility that it is substance related. So he received a rule out for a substance induced psychosis. And then of course, the substances that he was known to use are cannabis, methamphetamine, and alcohol.
Okay. And after that was done, was there an instrument used to determine whether he was actually competent to stand trial?
Yes, I use the competency to stand trial assessment instrument with my patients.
Okay, and how did Mr. Humphrey perform in that?
So Mr. Humphrey was very cooperative with this portion of the evaluation, which is good. I think if you read my report carefully, you can see that he was not very cooperative when he came to KCPC. He was medicated and then he became more cooperative. So I felt that he provided good effort. He answered questions accurately or properly for the most part. If he didn't know the answer, I educated him and then he was able to recall that information later in the evaluation, which is of course something important. And overall, I felt that he did not have any mental condition at the time of that evaluation that interfered with trial competency.
Okay. Based on your examination of the defendant, have you reached an opinion as regarding his?
Yes, you're breaking up just a little bit.
Oh, I'm sorry. I stepped back just a little bit from the mic.
That's okay. Yeah, so at the time of the writing of my report, this would have been at the end of May 2023. It was my opinion that Mr. Humphrey did have the capacity to understand and appreciate the nature and the consequences of the proceedings against him, and he could participate rationally and cooperatively in his defense.
I'll pass the witness, Your Honor.
Counselor.
Yes. Dr. Turns, can you hear me okay?
I can.
Okay. Dr. Turns, you testified that you upon intake with Mr. Humphrey, you had reviewed documents. Was one of those documents a report that was prepared by Dr. Rancine?
Yes,
And that was a report, and Dr. Rancine is a KCPC evaluator, is that correct?
yes, he does the outpatient evaluations, either in person or via video conference.
And in that report, did you notice that he was given a psychiatric diagnosis of unspecified psychotic disorder, schizophrenia?
Yes, well, actually, what I have written down is unspecified psychotic disorder. I don't have the schizophrenia part. I don't have that report right in front of me.
I believe it states schizophrenia versus schizoaffective disorder.
Okay, well, I'll trust you on that. I don't have that in front of me.
Okay. And in that report, do you remember where he was referred for inpatient to receive treatment? Is that correct?
Yes, Dr. Rancine opined that Mr. Humphrey was not competent and then felt that he could be restored with inpatient treatment at KCPC.
And what inpatient treatment did he receive while at KCPC?
So when we're dealing with someone who has psychosis, the primary mode of treatment is going to be antipsychotic medications. And so when he was with us, let me kind of flip to that part of my report. Looks like here, he had been given some Zyprexa in the jail, and we increased that when he came to us. And then through the course of his time with us, he was maintained on that antipsychotic medication, the Zyprexa, and his doctor elected to also add a mood stabilizer that's called Depakote. That was added. And then Mr. Humphrey was reported that he was having problems with depression, and his doctor elected to add Prozac, which is an antidepressant, to his medication regimen. And those three medicines were the medications that he was discharged on.
And Dr. Turns, one of the things in your report that you note was needing to rule out a substance abuse psychosis. Was he drug tested while at KCPC?
He was not.
And he went to KCPC directly from the jail. Is that correct?
As far as I know, yes.
Okay. Do you happen to know how long he had been in jail prior to going to KCPC?
I can look it up here. I might have that. It's not always accurate, but it looks like his date of incarceration was June 2nd, 2022. I think that's what I have anyway.
Okay. But even though the substance abuse would need to be ruled out, no drug testing was done.
That's right.
Okay. And did Mr. Humphrey self-report the last date of any use?
We got information from his mother on that. We had a little bit of trouble collecting information at the time of admission because he wasn't very cooperative. And so, according to my report anyway, we did get most of that information from his mother. Generally, I mean, I can review kind of what she said if you like, or you can just ask me questions.
So when his mother reported, she reported use that was prior to his incarceration, correct?
Yes.
Okay, and some of it actually went back several years ago.
That's right.
Okay. And the only thing Mr. Humphrey had reported to you was recent use of alcohol prior to his incarceration. Was that correct?
So when he spoke with me, it looks like he said that he had previously used cannabis in the past. According to his mother, there was alcohol, methamphetamine, and I believe, let's see here. I believe bear with me. It's hard. I'm trying to find where yeah, so she said methamphetamine, abuse of pain pills, and chewing fentanyl patches was what she had
It's not-
reported.
That's not me.
It's okay, Mr. Humphrey. And that was prior to his incarceration in June of 2022, correct?
According to the mother, yes.
Okay,
That's not me.
it's okay, Mr. Humphrey. But that was a report by his mother, correct? That was, and she did not give any dates as to that. Is that correct?
Yes.
Okay. And you note in your report that you didn't see any notable issues with personality. Was it concerning to you that Dr. Rancine had noted significant thought disruption, including audio and visual issues?
Well, I don't know when Dr. Rancine saw the patient. I don't know if he was medicated at the time. So no, it wouldn't surprise me actually that someone in the jail might be exhibiting signs of psychosis.
And did Mr. Humphrey indicate or demonstrate any issues of audio and visual hallucinations while under your care?
So it looks like at the time of admission, we didn't see a lot of sort of overt psychosis or obvious signs of psychosis, like active hallucinating, things of that nature. And I think I'm guessing, because I don't know when the Zyprexa was started in the jail, I'm guessing that he was achieving some benefit from that in the jail before he got to us. And then when he got to us, I think he was doing a little bit better and then continued to get better at our facility.
And to your knowledge, is he continuing to take that medication while incarcerated?
I don't know if he is or not.
In your opinion, would it be necessary for his competency to continue taking those medications?
Yes, along with abstinence from substances. Yes, it does. I do believe that.
Nothing further, Your Honor.
You have an argument?
Yes, Your Honor, the only evidence that put forward in this matter is that he's competent to stand trial at this time based on the treatment that he's received.
Your Honor, I think competency is an ongoing issue. I understand the doctor's report. I do think that it would be necessary for the court to know if he is currently receiving his medications while at the jail, because given what the doctor just said, that would weigh on his ability to continue to remain competent.
We can sign a waiver for you to obtain that sort of information from jail. I suggest you do that.
Okay.
Mr. Humphrey, your attorney's going to come see you and ask you to sign a paper that allow her to get the medical information from the jail that she needs to defend you. That's your decision after talking to her, whether you sign it or not, okay?
All right.
Doctor, you're excused. Thank you for being patient with us today.
Thank you.
I'm going to enter an order finding him to be competent at this juncture. And what's your next step here?
Your Honor, Mr. Stockton and I had already discussed possibly setting this for a settlement on the 12th, given what we.
12th and the 27th, okay? Mr. Humphrey, they're going to come up and talk to you about a settlement conference and next appearance. Thank you very much. Is there anything else at the Dare County Jail that we have?
When are they gonna come see me, Judge?
Tomorrow, when you go? When you go come see me?
I'm
Monday?
gonna do my absolute best to be there tomorrow, but it may be Monday afternoon.
It'll either be tomorrow or Monday, okay?
All right.
Okay, see you. You have a great day.
You too, Judge.
Okay, now we'll ask the courtroom to be cleared for a ex parte hearing. Sure. You'll be here too. Okay, we're gonna do the show cause docket. And the clerk's office helped me with this, in case there's anything to say. Michaela Beatty, okay, issue a bench warrant. And she can purge herself by paying $170. Claude B. Cole,
Same thing again. It's no notice, no notice.
purge himself by paying $725. Mr. Bertram, could you turn your camera off till your case gets called?
Certainly.
Thank you very much. Aiden Fields. This is Aiden Fields. Yes, sir. You owe $450. What can you do?
Can't do anything right now. So I get another job. I said I can't do anything right now, so I get another job.
Well, you have $50 paid by the end of business today. Okay, and then you pay $50 a month.
Okay.
Every month.
Okay.
Start 30 days, you pay 50 today and $50 every month. Or you'll have to serve it out in jail. Okay?
Yep.
So have $50 in the clerk's office by the end of court today.
Okay.
You understand that?
Got you.
Okay, thank you.
Yeah.
Brandon Gadberry. Send him, put a bench warrant out with, get out with $50. Tia Hancock,
She came in this one and paid $50.
how much more does she owe? You owe $25 more. Okay, I'll let you have 30 days, okay?
I'm here once a week.
Okay, if you have $25 more for 30 days from now, you're a free woman, all right?
All right, well,
Okay,
not
thank you
applying
very
to drug
much.
court, but
James Craig. James, you owe $185. What's the deal?
I was confused, Your Honor, about, I was talking with Samantha Costello, my lawyer, and I thought that the deal that I took, that I didn't have to, have the court.
Well, I'll give you
costs.
some time.
I got a job though. I can pay half of it next week.
You don't have to do that. I tell you what, you pay $35 a month, starting 30 days from today,
Okay,
okay?
all right. Thank you.
You do that. Can you pay 35 today?
I can't till I can next Friday.
Okay, we'll have 35 by next Friday and then 35 a month, every 30 days to pay it off. It just take you, 5 months to do
Okay.
it. All right, thank you very
sir.
much for being here. Christina Murphy. Christina Murphy. Okay, have a bench warrant. She can purge herself for $165. Elizabeth Scott. You got 2 cases, Elizabeth. You got one in 1526 and 109. You paid $50 today. You pay $50 a month every 30 days. Can you do that?
Yeah.
Hate to send you to jail.
no, I don't want to go.
I
I'll pay
know,
the
well,
MI.
that's good. That shows you don't need a competency hearing today. You don't want to go to jail. That's a
That's right.
start, right?
Yep.
So you make them on time.
Okay. Is it due on the first of every month?
Yeah, you make one today and make it an anniversary. Well, yeah, first a month.
Okay,
Yeah.
That's
you
good.
Make July, except it'd be starting 1st of August. I'll count this one as your 1st of July.
Okay.
Okay.
okay, thank you.
Okay. Jimmy D. Smith. Jimmy D. Smith. Okay. Enter an order of arrest for yourself paying $725. Deshaun Tucker,
We don't have one.
$210 is your bench warrant purged with $210. Mitchell York, $799. How long has it been since the payment has been made? Okay. Bench warrant. Purge himself by $799.85. Is there anyone else here on the show cause docket that would like to be heard? Okay, thank you very much. Okay, now we come up, when's the child support document now?
I'm ready.
Is it scheduled for one? Was it?
It's noticed for one, I believe.
Okay. You don't have anybody on the child support docket today?
I have one case
Come around and bring it. Let's see what you got.
to the Commonwealth, Kentucky versus Cole Wenzel. It's just a motion to intervene on behalf of the petitioner.
Doesn't surrender civil document. I'll submit an order.
I have no.
And I'll do that.
Thank you, Judge.
Okay.
That's all I
You got
have.
anything else?
That's all I've got.
Do we have anything else? Is civil docket scheduled for now? 1:15, we're ready to go.
Thank you, Judge.
Yeah, see. Are you gonna be around for a minute or you leave?
Yes, I will.
Okay, civil docket. 1:15 and now we're almost ready to catch up. Have a great day. Good seeing you. Chambers versus Chambers.
This is Ms. Henley. I'm appearing remotely on behalf of Eric Chambers.
What is this?
Your Honor, this is their motion for contempt on behalf of Eric Chambers.
Could you identify yourself?
Yes, Your Honor, this is Allison Henley, attorney for Eric Chambers.
Okay, this is 20 CI 0036. What do
Yes,
you
Your
have?
Honor.
Okay, tell me what you have to say.
Yes, Your Honor. There was an order entered by this court in November of 2022 that ordered Ms. Chambers to comply with the terms of getting the USDA loan out of her name and just stay current on all payments. And we filed this motion because she has not done that. They have provided proof that after we filed the motion, she did it.
You need to slow down a little bit. I cannot understand what you're saying because the microphone's not picking up. The motion I have here is to allow them to speak directly to the children's motion I have. Is there another motion?
I believe that was attached in the bottom of the communication motion referencing the USDA loan.
Okay, your client was supposed to get the USDA loan.
Yes, she was supposed to have the petitioner's name removed from that.
Has she done that?
Yes, Your Honor.
Okay. Counselor, she says she's done that. Can you send proof to her today that's been done?
Your Honor, I have provided proof. It was just a lengthy process dealing
Okay,
with.
that's been accomplished, Counselor.
Yes, Your Honor, it was just his position that we had to file numerous motions to get that done. And that it was done after we filed the motion. So he was just still wanting me to seek some sort of relief.
Make sure that's done. Now let's go on to the other issue.
Yes, Your Honor, the other
Or
issue.
you want me to order the grandmother to do something? I don't think the grandmother's before the court.
She's not, Your Honor. If I could explain the situation on that one. My client, there's been instances when the grandmother is taking care of the child and the children, and he will have no access to them to know, to be able to communicate with them through the phone. They also have the practice of doing video calls, given the children's ages. He would just ask that whoever the caretaker is, he understands if the grandmother doesn't want to be friends on social media, that's fine. He would just like that there to be an order in place where he could always have the opportunity to have a phone or video conferencing with whoever.
Your Honor, the
You have to
petition.
speak up a little bit, please.
Your Honor, the petitioner has been provided with the maternal grandmother's cell phone number. It's the same number they had during the whole 8-year course of marriage. And she has agreed she's not going to impede any type of communication. She just wishes for it to be via telephone and not a video communication. She's also not.
When the children are with the grandmother.
Yes, Your Honor. She's
Okay,
also
did
not
you-
a resident.
Did you
of the
hear
state.
that?
Yes, Your Honor. He still, just due to the children's ages, would like there to be video. And also he was under the impression, I think at one point he believes blocked where he could not communicate at all with the children. through the grandmother. So certainly we don't want that to happen.
Okay, well, if the grandmother continues to be in a supervisory capacity of the children left with her, they shall have access to a cell phone. I'm not gonna make Facebook or any of that other stuff happen or. So that takes care of the two things. Is there anything else you want?
I don't think so, Your Honor. Thank you
So
very
have a
much.
great day, and I guess you're gonna draft the order and send it.
Yes, Your Honor.
Ms. Perigin will draft the order and send it to you, and then I'll enter it, okay?
Okay, thank you, Your Honor. Have a
Thank
great
you,
day.
yeah, okay. Carver and others versus Brandon.
Good afternoon.
Hello, how are y'all doing?
Good afternoon, Judge.
Your Honor, this is on for plaintiff's motion for summary judgment.
I've read it.
Read everything.
You didn't file a response to this.
I did this morning, Your
Well,
Honor.
that's not very good to wait till this morning.
I understand that, Your Honor. I contacted Mr. Harris' office. I had some,
What is your response to it?
Your Honor, response, the overarch, I've got about 4 or 5 things if I could.
I'd be glad to listen to all of them.
All right. First of all, the overarching argument, Your Honor, is the matter is not ripe for summary. Discovery is not completed.
Well, here,
And the issue,
let's get to something else. The interim clause, say how you say it,
Interim.
interim, and it's like tomato, isn't it?
Yeah.
yes,
How you gonna get around that?
Your Honor, the cases, even the cases, I'll just skip to
Yeah.
that. Even the cases that Mr. Harris cited for the proposition of the interim clause, the Hurley decision makes it clear that there was a prior litigation in that very case that went to the appeals court that dealt with the issue of whether the will was validly executed, whether there was undue influence, coercion, those sorts of things. And then after that decision was made, the court took up the case of the interim clause. There's another case.
So the issue is, was it properly executed? If it wasn't executed, then you couldn't effectuate the interim clause.
Correct.
Yeah. Well, I will tell you after reading this, this document bothers me a little bit. It's drafted by an attorney whose husband witnesses it and who she notarizes. And what do you have to say about that?
Your Honor, I don't know that there's any preclusion under the law for him to be a witness, number one. Number two, this will is very specific to what it lays out, more so than most wills that you see. I would also point out.
Here's the thing about it is, I know it's very technical and specific. I've read it 2 or 3 times because it was attached to your motion. But most people don't have the legal sophistication to write a document like that. It's written by an attorney. One of the most complex, I mean, it looked like it was written for the Rockefellers or something. I don't know, but.
And Your Honor, that was one of the points that I made in my written response. I stated in there, Mr. Smith's will itself is a cloud of suspicion in the eyes of the plaintiffs. The preparation and discussions leading up to that, it's a rather unusual will, 7 pages long, 30+ pages of attachments with deeds, leases, memorandums, letters. These are extraordinary in nature, typically not in wills. It appears to assemble some sort of paper trail, if you will.
Yeah, well,
and so that was
what's the other?
Well, Your Honor, the thing about it is, number one, in the response was filed today, this motion's been pending for a while.
That bothers me.
There is no affidavits. Regardless of what Your Honor made, the will has everything it needs, stated what the law requires is very simply, if I can get to it, the requirements for a valid will, no will is all that.
You don't have to get there yet.
Okay,
You
yes.
what you need to get to is what you have to do to keep a motion for summary judgment from happening. You need to file a response with an affidavit attached, correct? Isn't that right?
Yeah, well, Your Honor, the motion that was filed by Mr. Harris was a legal issue. It was not anything based on facts. And so the only affidavit that he uses is the affidavit that was used to
probate the will, which is in every will contest case. What I am asking the court is to allow me to.
It's interesting to determine whether that interim clause is a factual or legal question. You know, I mean.
And Your Honor, if I could, one of the big depositions that we've not been able to take, we had it scheduled one time, and Mr. Harris had a church function that obviously we rescheduled it, and then it was scheduled again. And
What are we fighting over here? I looked at the will and it appeared to me to have fairly evenly distributed the assets between the three daughters. What is it that we're fighting over? If we could kind of cut to the
house.
Yeah.
The house,
What did the house?
it had a mortgage of about 160,000 against it at the time.
Yeah,
So, you know, and my client has been making those mortgage payments
yeah.
on that house. So, Your Honor, you're right. But if I could address the affidavits, these affidavits were prepared.
Well,
for
let's
this
go back to
lawsuit.
what we're fighting over.
Yeah.
Okay. What I'd like to do is get out of this thing with everybody feeling like they've gotten their fair share out of this estate. I didn't see anything facially on the will that indicated, and I knew Mr. Smith, and thought highly of him. You know, who knew his deceased wife. I don't see anything that's as far as the distribution under the estate that was brought to me. Go back to the house again. Now the house was there and had a mortgage on it, right? How much was the house worth?
I have no idea.
Well,
Not
so
sure.
what are we fighting over here? If it had a mortgage against it? I mean, I expected to see something here that someone that was attorney in fact, or something that was an administrator had misspent some funds or something like that. I didn't see any of that sort of allegations.
Your Honor, and again, I apologize for the late response. And I would
I'm
ask-
talking about in the lawsuit. Are there allegations like that in a lawsuit?
Well, at this point.
Are there
No,
allegations
sir.
like that? So that's the only thing in front of me. But I was just saying, as someone that's lost a lot of these cases in the past, you know, or practiced them in the case, usually have something like that, and that's not before me. So what I'm asking you is, what is before? So there was 160. Has the house ever been sold?
No, my client lives in it and makes the mortgage payments.
Okay.
because It was left to
Well,
her by the father.
what about having the house appraised? Backing out the mortgage on it and splitting the equity 3 ways and letting this thing go.
Your Honor, they had reached out to us about 2 weeks before the motion was filed, seeing if we wanted to mediate it. We're fully willing to mediate it. And
Well, I could decide the legal issue after I read your brief on the interim clause, but you want to still take some testimony about undue influence.
and the execution of the will, Your Honor.
Yeah.
Because here's what we know from the discovery thus far. On the very day that he purportedly signed the will, he had a doctor's appointment at Cumberland Family Medical.
Yeah.
He weighed about 100 pounds, and the medical record on that day said that he was in acute respiratory distress.
Yeah.
He went to the pharmacy that same day to get lorazepam prescription refilled. We know that 3 months prior to the execution of the will, a power of attorney was executed granting Ms. Kristen Branham his attorney in fact.
Yeah.
We know from discovery of his financial records that in October of 2020, there was a document that was signed transferring the primary beneficiary of his annuity to Ms. Branham, who was attorney in fact at the time. We questioned the validity of the signature on that.
That's
form.
not in front of me though.
But what I believe, Your Honor, it argues it goes to the badges of undue
I
influence.
understand that. So that's the reason before we go down that dirt road and get involved in that, it might be smart for everybody to make a settlement on the house and let the will go, unless there's some overarching things that you think you need to do. I mean, I would think his client would want a complete release from all those other potential problems if that happened.
Your Honor, that's true. Of course, the other thing that Your Honor has mentioned is this idea of the interim clause, or however you say it. our position is, my client's been drug through the mud over this and over the house that had a mortgage on it that she's paying. And her father had the right to leave that house to whoever he wanted to, could have left it to his favorite attorney or anybody. And the will,
I understand that. and I
but the
understand
point
Paul, I
being
understand-
is
I understand the point you're trying to.
the point I'm making is the Wayne County real estate's probably worth at least 100,000. So if we're going to talk about settling, it's our
Did they get
position.
it instead of her? I thought
They
all
get a
this-
third each, but
I
if
thought all of them got a third each.
they get a third each of everything, but since they brought this action and put my client through this, if the will is found to be the valid will, which we feel very strongly that it is, and even though she went to the doctor that day, the records will show, and I don't think there's any finding by her that he was incompetent. And we look at the case law we cited in our brief, whether you're old or all those things.
Well, let me tell you what's gonna happen. If I rule that the interim clause is correct, it goes up on appeal, we don't know what's gonna happen. Right. This case goes to a jury in Cumberland County, they're gonna split this thing 3 ways. I've been in too many juries. So there's a good thing about certainty. That's all I'm saying. I'm
I understand.
not
I understand
trying to-
what you're
I'm
saying.
not trying to mediate the thing. I will decide it on the law, what I believe the law is, okay?
I
But what
understand.
I'm telling you, a word to the wise is sufficient. And I don't know whether anybody, with the present state of the world, I don't know whether anybody can get drugged through the mud and anybody believes anything anybody says about anybody else, right? Everybody's gonna have their opinion. If they like one party, their friends of theirs, they're gonna believe what they said and vice versa. And, you know, there's always redemption for everybody, no matter what they've done. You and I, we all believe that. And there's also reconciliation and there's also bringing people together. I hope that happens.
I do too.
But it's not within my province to order that to happen. I hope it happens.
The only reason I made that comment is you were talking about just whatever equity there is in the house, 1/3 each, but from my client's side, we have to look at, okay, if the will is upheld and they are taken out, then they're going to give up their 2/3 interest in the Wayne County property, which probably has a value of 60-some thousand.
Yeah,
So-
well, what I'm telling you is if that house is worth $300,000, I know where the house is. I've never been in the house or anything, but let's say it's worth $300,000. And there's $160,000 mortgage still left on it, and she can show payments that she made out of her own resources. Some kind of offset, for it, and they divide the rest of it 3,000. You're talking about a pittance difference in it rather than putting it at risk of the increased litigation things. That's just what I'm saying.
We have mentioned about the possibility of trying to settle this. And I would just ask.
What is a mediator that would be acceptable to both? I'll tell you, somebody that's gotten into mediation that's an interesting person is Justice Minton, former Supreme Court Justice. Do you know him? Either one of you know him? What about ordering a mediation in this thing and let Justice Minton cut his teeth as a new mediator, or Jimmy White down in Salina is available for mediation, but he doesn't understand. He hadn't figured out whether that's practicing law up here, and he's not licensed up here. So I better go with Justice Minton.
Your Honor, we would be fine with Justice Minton.
I would recommend Bobby Richardson does it sometime, but I don't think that would be appropriate in this case.
No, sir.
But you can't ever tell about Bobby. Phil Patton does it, you know.
Jimbo Mattingly does it. Jimbo's interesting.
Yeah. Well, if y'all just agree upon someone, any of those people that you've named with the exclusion of Jimmy White and Bobby Richardson would be all right. And let's redocket this thing for next rule day. Hopefully you'll have it settled. You get an appraisal and see if they can work something out. Yeah. All right. And let's try to work through this thing, because and I read some stuff on this. I believe there is some law in the execution situations for is the clause. Obviously, it would make sense that you could put a clause in there and obviate the necessity to prove that there wasn't undue influence and those sort of things like that. They can't happen. But and I also would like for y'all to look to see when you have an attorney draft something and have her husband witness it, and then she notarizes his signature. Now, where does Margaret Burns fit into this thing?
She was one of the subscribing witnesses.
I know, but who is she?
She, I think, is a friend of Ms. Thomas's.
You know, is that right?
It may be, Your Honor. I know that the two witnesses are not related to the testator.
Yeah.
And I think if it was a family member or something like that of the testator, but my opinion, without doing legal research on it at this moment, is that you can have any two witnesses you want. I don't think the fact
Well, I
that
would
that's your
think-
husband or a friend, that,
Well, I don't think a friend would be, because everybody's our friend.
You know, my
but
wife-
I used to go across the street at the Bank of Cumberland and just get whoever was in there working at the time, who was known in the community, have certain fiduciary duties and that sort of thing. Miss Wells quite frequently would be captured by me and some of those older people that are gone now. Not that she's old, she's the youngest one over there, but
when my wife was practicing, I'm sure there were times she witnessed wills that I prepared for people. And there's another example of a husband.
I
and
never
wife.
did that. Because I did have a wife that was practicing me for a while, but
You never did that.
we never did that.
I don't
But
think
didn't
it's
do that
prohibited.
many wills, and I wouldn't let my secretary do it, and I surely I wouldn't have notarized one. But whether that's not the best practice or whether it's illegal is two different questions. Okay, well, thank you all for your patience. And
Do you need me to renotice it for the next motion hour
and
day?
do an
or what?
order referring it for mediation and renotice it for the next thing, or y'all can just renotice it if you hadn't come to conclusion. Okay.
All right.
Okay, thank y'all very much for your patience.
Thank you very much.
Thank you, Judge.
Now, this is KFB MIC acting on behalf of Bruno Grubb versus Candace Staten. That was just an order that was submitted as far as amending the previous judgment.
That's correct, Your Honor. It's John Miller's motion, my partner.
Yes.
On his behalf. We're trying to clean up our error in all candor, Your Honor. We filed a motion for default judgment. It was granted.
I read it and I'm going
Okay.
to order.
Great. Thank you, Your Honor.
And I think the order was submitted.
It was, yes, sir.
It was a subrogation situation, correct?
That is exactly right.
Okay, I think it's appropriate.
Thank you very much, if I may be excused.
Yeah, absolutely. Thank you for your patience.
Thank you.
Sarah Wenzel versus Cole Wenzel.
That's what Mr. Hurt did here.
Yeah, that Mr. Hurt submitted an order on that as far as intervening in that case on behalf of the Commonwealth. Green River Rentals versus United Petroleum Transports. I will take that under advisement. It was a motion for summary judgment. And David Freeman versus Billy Freeman. Do you represent this? Are you,
I represent Mr. David Freeman.
you're the petitioner?
Yes.
She's a petitioner. And where is Billy Freeman?
She is in Murphy, North Carolina.
Yeah, so you just want a divorce. Is there property settlement or anything in your motion?
No, Judge, there's no property issues. The only issue is the visitation with the minor children and
Did
Miss.
she leave and take them?
No, she left them in the care of Mr. Freeman
Yeah.
and has also not completed her fit class requirement.
Okay, well, give me a default judgment of divorce. Place the children with him. And then you can renotice when she appears. She can renotice to set visitation, and the visitation will not be set till she finishes the fit program. Okay,
Thank you, Judge.
okay, thank you very much.
That's the order that she prepared.
Let's see how sad it is. Okay, let's go off the record till 2:00 when the jury is coming. Get the attorneys for the cabinet are in one of those side rooms back there. Did you see which room they're in? Yeah, could you have them come in here? The cabinet, yeah, they're gonna have to wait till we see the jury.
I know we did that upstairs.
This needs to be put back. That needs to be really Yes, go back to me. And so, there you go. Sure. How you doing? I'm all right. Judge, I apologize for that late filing. I